Afternoon, ladies and gentlemen, very warm welcome to ASSOCHAM National Conference on Ease of Justice in India, Future of Arbitration, Mediation and Conciliation. May I request honorable guests to please join us on the dais. Join kara nahi. Ladies and gentlemen, this conference is being organized by ASSOCHAM as an initiative of ASSOCHAM International Council for Alternate Dispute Resolution, ASSOCHAM National Council for Arbitration and Mediation, and ASSOCHAM National Council for Legal Affairs Regulatory Reforms, which are being the part of the important 100 such initiatives which add credits to ASSOCHAM to be known as an impactful representative of Indian industry to government. Ladies and gentlemen, please welcome our honorable chief guest who has joined virtually. We have with us Justice Deepak Misra, former Chief Justice of India. We welcome you, sir. We welcome Guest of Honor, Justice Sri Z.R. Mida, former Judge, Delhi High Court. Ladies and gentlemen, please welcome our Guest of Honor. We have a special guest, CA Dr. Ashok Haldia, Chairman, Indian Institute of Insolvency Professionals of ICAI. We welcome you, sir. We have Advocate K.K. Sharma ji. He is the Chairman of ASSOCHAM National Council for Arbitration and Mediation, and he is Senior Advocate in Practice in Supreme Court of India. Please warmly welcome him. We have Mr. Vasudev Mukherjee, Assistant Secretary General, ASSOCHAM. Now, we have very, very eminent guests and speakers who will be joining shortly. Some of them they have joined, some of them they are on the way. We welcome all of you to this conference. I would like to first request to all the dignitaries on the dais to please come forward and join for lamp lighting ceremony.
कुरुत्वं कल्याणं आरोग्यं धनसम्पदः शुभं कुरुत्वं कल्याणं आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तुते दीपज्योतिर्नमोऽस्तुते शुभं कुरुत्वं.
May we also request Ms. Deepa Agarwal to please join for lamp lighting. We have Dr. Raman Agarwal, please to join for lamp lighting, sir. Thank you very much, all of you, for your kind lamp lighting. Before we start, may I request all of you to please keep your mobile phone switched off or on silent mode. At the outset, I would like to just give a brief. And before that, I would like to request Team ASSOCHAM to please assist me, and would request Advocate K.K. Sharma sir to please present the welcome plan to our honorable guest of honor. May I also request Mr. Vasudev Mukherjee to please present the welcome flower to our special guest, Dr. Ashok Haldia. Thank you very much. Ladies and gentlemen, ASSOCHAM is the country's oldest apex chamber. It brings in actionable insights to strengthen the Indian economy, leveraging its network of more than 4.5 lakh members, of which MSME represents a large segment. With a strong presence in states and key cities globally, ASSOCHAM has also more than 400 associations, federations, and regional chambers in its fold. Aligned with its vision of creating a new India, ASSOCHAM works as a conduit between industry and the government. ASSOCHAM is driving 4 strategic priorities: sustainability, empowerment, entrepreneurship, and digitization. The Chamber believes that affirmative action in these areas would help drive an inclusive and sustainable socio-economic growth for the country. The legal councils are led by well-known luminaries, including professionals with background of Supreme Court judges and High Court judges, law practitioners, individuals, professionals, and law firms, law universities and institutions, general counsels, and independent professionals. This conference is being supported by Bombay Stock Exchange Investor Protection Fund, Jupiter's Justice Technology Partner as technology partner. We are supported by Reliance Industries. Event partner is Renew Power, supported by SpiceJet, TCI Group, and magazine partner is Witness, and media partner is Losted. Ladies and gentlemen, we missed a lot in the webinars over last 2 years experience, and now we have opportunity of physically meeting in this conference after so long due to the pandemic reasons. And hence there is a reason for making this occasion and mark it as a special one, and we can celebrate it. So may I request all of you to please welcome all the dignitaries and all your good self by your benign presence, and please give a huge round of applause to all of us over here. Thank you so much. At the outset, I would like to welcome Advocate K.K. Sharma, Chairman, ASSOCHAM National Council for Arbitration and Mediation, and Senior Advocate in Practice, Supreme Court of India, to kindly give the opening remarks and welcome address. Over to you, sir.
Thank you, Mr. Santosh. In fact, you have already opened, and you asked me to give a remark. Thank you. Well, gentlemen, I'm K.K. Sharma. I'm a senior advocate, and very warm welcome to you. But before that, good evening to all of you. Good afternoon, rather, I must say. Dear, this pandemic really has kept indoors. So we thought, let's start coming out now. Of course, again, there's a threat, maybe a small one, but it's coming. But we are not really scared of that. We have to work. We have to recharge our batteries. So today we got a chance because Mr. Parasha said, Mr. Deepak Sood, our Secretary General, ASSOCHAM, has said, green signal, go ahead now, and in full-fledged way, and whatever we can spread, our knowledge, whatever little knowledge we have, and the experience of all honorable judges of Supreme Court and High Court, we should spread to the people who are interested to understand and to listen that. So for that purpose, we are here together. I welcome all of you, and especially, I think it's my honor to welcome all of you and to the conference on the Ease of Justice of India, Ease of Justice in India, organized by ASSOCHAM. ASSOCHAM, as Mr. Santosh told you, is more than 100 years old chamber. I think it was established sometime in 1918. More than 100 years have gone. So we are the oldest chamber in India. I would like to extend my warm welcome to the Chief Justice, former Chief Justice of India, Justice Deepak Mishra Sahab, who is going to enlighten us, impart us knowledge about the subject. I also give a warm welcome to a great friend of mine who has been a great lawyer also and a great judge in the history of Delhi High Court, Mr. Justice Midha. He is in front of you. He has been a great judge in Delhi High Court history, and I have special love for him, a special regard for him, and not only me but everybody. Dear, I'm delighted to have this opportunity to welcoming these special guests here. I'm grateful to the guests for giving us their valuable time and joining us on such an interactive session. I'm also grateful to the ASSOCHAM for organizing such a session which will promote justice in an easy way for the masses. Also, this kind of conferences are going to have some kind of impact on the arbitrations, mediations, and conciliation futures. And that is the purpose for today's conference. Dear, in fact, on 10th of February, I was invited to the Parliament because a bill was passed, bill was introduced in the Rajya Sabha, that's known as the Mediation Bill 2021. And on that, I had to speak on the subject because the mediation is going to take place like arbitration now. And I have already told my Justice Mr. Vidham, my friend, that he has to help us and enlighten us about the mediation also, because the act is going to come. It has already been put in the parliament. Now it has been sent to the what you call select committee or standing committee. And I addressed the standing committee on 10th of February. So that is the basic purpose, to discuss about the mediation, because I understand one of my Mr. Ashok is here. Haldia was saying that there is no mediation in the IBC. So that may be one of the subjects which can be discussed today. And I think probably everybody will be free to discuss whatever you have thoughts in your mind. Dear, let me come back to the topic that COVID-19 pandemic has been extremely unfortunate, but as two sides of the same coin. The pandemic also taught a lot to a lot of us about the importance of artificial intelligence and how everything can be achieved within this, with ease, without any difficulty. Be it justice, the courts have been functioning through virtual mode, and we all adapted to the same. The new phase of e-justice through various cloud-based system and artificial intelligence came as a game changer in the justice delivery system. Everybody knows. Arbitration had always been a better choice than litigation, considering the lot of factors. With the addition of artificial intelligence in the field of justice system, it has become blessing in disguise, and even with more benefits such as time effective, cost effective, and convenience, etc. In India as well as abroad, across the countries, all over the world, everybody is turning towards the ADR, this alternate dispute resolution. And we are not an exception. We are working last almost a decade, and we have achieved a quite good way. In the recent years of rapid globalization, time is the essence, and with the increase of number of cases pending in the courts, arbitration really bloomed. Mostly the commercial sector started with arbitration, but today arbitrations comes to rescue in all forms of cases. The introduction of mediation bill in the Rajya Sabha on December 20, 2021 to promote and facilitate mediation, especially institutional mediation for resolution of disputes, commercial or otherwise, is yet another class example of how fast we are shaping to new ways of not only reducing the burden of the courts, but also saving time. The Commercial Courts Act mandates the process of mediation, which makes it institutionalized, just like arbitration. Mediation as a first step involves a lot of issues. Even before it is brought to the doorstep of courts, the parties are more adaptable to ease yet effective solution than a formal lengthy procedure adopted in the courts. India is seen as one of the most attractive manufacturing hubs all over the world. As more and more international businesses houses are attempting to enter in India with the vast potential of Indian market to avoid cumbersome legal proceedings, inclusion of arbitration clauses are adopted in the contract. The arbitration, mediation, and conciliations are opted as a best remedy for all kinds of commercial disputes by the people who are not only Indians but the foreign nationals as well. The report of the high-level committee to review the institutionalization of the arbitration mechanism in India, also known as the Shri Krishna Committee report, which came in 2017, had also recommended third-party funding with respect to arbitration in India. This is a very, very important subject, third-party funding. Probably Mr. Justice Midha will apprise you. It is not valid so far or legal so far in India, but all over the world it is being done. Third party funds the litigation. It is to be dealt in a different way in past about 50 years ago, and I think there was a section also in Transfer Property Act, section 6E, that you cannot transfer the right to sue. But here, right to sue may not be transferred, but you can fund a person and you go ahead with the litigation. I'm at your back. I'll pay the money to you. So this kind of system is prevalent abroad. It is going to come to India. Probably some of the speakers may come up and speak about that also. We'll be happy to hear them also. So gentlemen, I will not take much time because I'm not the main speaker. Speakers are here. So thank you very much for joining us, and thank you all of you. And before I depart, I want to make a small announcement. Not announcement exactly, but because we are going to have a more important international arbitration conference in London in the first week of July tentatively. The way we had the international conference or international arbitration in 2019 December in Delhi. So we are having speakers from all over the world on that conference. And if somebody is interested, they can start talking to us, or we'll be more happy, and Mr. Santosh Parashar is here, he'll be more happy to talk to you. So, but this is only a trail of today. So thank you very much. We welcome all of you. Thanks, Ethan.
Thank you, Advocate K.K. Sharma sir. May I just remind all of you, as the health is foremost important, so unless this is very much essential, we may keep wearing our mask. I may be exception for the moment. Now, let me take the opportunity of inviting our special guest, Dr. Ashok Haldia, CA Dr. Ashok Haldia. He's the chairman of Indian Institute of Insolvency Professionals of ICAI. I invite you, sir. Please welcome Dr. Ashok Haldia, sir.
Thank you, Santoshji. Very good afternoon, ladies and gentlemen. Indeed, a great pleasure to be here before distinguished participants and the guests on the subject so important, arbitration, conciliation, and mediation. Honorable Justice, Chief Justice of India, former Shri Deepak Mishra, Honorable Justice Shri Midha, Senior Advocate Shri K.K. Sharma, Shri Vasudev Mukherjee, ladies and gentlemen. The topic of the day is very, very topical. The ease of justice in India and future of arbitration, mediation, and conciliation. I am a chairman of Indian Institute of Insolvency Professionals, the largest frontline regulator for the insolvency professionals. The institute regulates the profession, it develops the profession, it is also quasi-judicial body. I'm happy that in the topics for discussions that follow in the technical session is one of the often forgotten topic of absence of arbitration, mediation, or conciliation proceedings under the Insolvency and Bankruptcy Code. We have been emphasizing all along that this is a very important part of the very genesis spirit of IBC, and therefore the government should come out with a mechanism to facilitate mediation and the conciliation. What is the objective of ADR, that is Alternative Dispute Resolution? It is using the direct approach to settle the dispute through conversation, discussions, and also through better understanding among the parties of the issues involved, and also better understanding of the parties. As I said, this is also very fundamental premise on which the IBC is built upon. IBC is not mere law, is not mere management, is not mere transition. It's a transition, it's a management in the sense that involves the human beings, it involves the emotions, and therefore when we think of a resolution plan, we have to think in a larger context, how to bring together the minds and heart in order to achieve the purpose in a fair and transparent manner. And I believe for that purpose, the mediation and conciliation can be very helpful. Arbitration, as I said, the mediation and the conciliation are not recognized under the IBC. But there are different provisions under the IBC and the new developments which often emphasize and lay thrust on the conciliations. Recently, the pre-pack mechanism has been introduced, which is an informal mechanism given a color of formality or the legal later on. There is a provision for withdrawal of insolvency proceedings, and a large number of cases are withdrawn. Idea possibly is to enable them, if they come to some conciliation, to facilitate them to go out of the IBC proceedings and settle the matter. About 17% of the total cases under the IBC are withdrawn and taken up for settlement. IBC has been a landmark legislation in the country. We have seen what transformation it has caused on the industrial landscape. I have been the part of evolution, the beginning of IBC way back in early 2000. It has taken 16 years to come. It has often been criticized, but then people fail to understand how it has evolved and what are the challenges with which the IBC was brought in steps, in stages, considering the ecosystem that we have, including the jurisprudence. Now, possibly the time has come that we recognize the mediation and the conciliation. What for IBC is criticized? Three things. That haircuts, only 31% is often realized. Delays, more than 400 days it takes. And lastly, that a large number of cases go into the liquidation proceedings. We carried out a study, which I was talking to the senior advocate, Mr. Sharma. This study is 2 years back, so the situation should be far more intense and difficult and bad now. We carried out a study as to what is the legal hurdles in the IBC process, in the CIRP process. I carried out a survey of 200 cases, maybe more than that. And our finding was quite startling. Every CIRP takes at least is engulfed into 3 legal cases, resulting into per CIRP cost of 20 lakhs. Total delays per CIRP is 113 days. Believe me, remember, 270 days is what the IBC allows, and 130 days takes away in the legal proceedings. And what is the total cost, legal cost? So good for the legal profession. I'm sure many of you come from a legal fraternity. 520 crores were on an average the cost at that point of time of these cases in the CIRP. I'm not surprised that it is one of the major practice areas for the professionals. Not bad, good thing, but possibly we need to think in terms of ease of justice and ease of resolution process. What needs to be done? We have already a law which facilitates mediation, conciliation, and arbitration. That law has not been recognized under the IBC. IBC may possibly, spirit of the IBC suggests that go for those. So there are some problems in that law. And possibly, what are those problems? We need to introspect, we need to see, and we need to match those problems to the spirit of the IBC. It has to be more open, transparent, less of the legalities. Parties are more of informal process, and once the informal process leads to some conciliation, then possibly give it a legal cover. In Singapore, they introduced conciliation in the insolvency process. But now there is a greater demand that it should be made mandatory. The conciliation should be made mandatory before somebody resorts to the CIRP or the insolvency process. Not that the need has been felt. One fails to understand why there has been lack of confidence into the conciliation proceedings, that it can bring together two differing individuals, two differing parties, and facilitate open, transparent discussions and amicable solutions, which later on gets the legal stamp. 2006 with 2008, we know the financial crisis. The USA came out with a paper and with a charter, which was possibly called Insolvency and Creditors' Right Standard, that recognized the judicial process and they did not recognize the mediation or the conciliation. So the focus all over the world, not only in India, has been on the judicial process. So what needs to be done? Facilitate conciliations, make it a part of the legal, part of the law, and make it more informal, and then once it reaches to finality, give it a legal cover. What four things that the law need to do? They want to accept, to accord legal recognition, to make arrangements for the enforceability of the conciliation decisions, to recognize professional bodies which can act as a mediation. It's a different ballgame altogether. It's not pure law. It's much more than a law, much more and much beyond than a law, bringing together two minds and hearts and then attempting a resolution. So separate, maybe reoriented the existing professional or bring a new class of professionals. And if this is an insolvency of individuals, all the more difficult because the cost involved has to be compatible, comparable, and the time taken has to be very minimal. Otherwise, the individuals would not come. And then to make the mediation as a voluntary process to begin with, and then later on thinking, giving it a legal cover, giving it a compulsory cover. So I'm sure the session in the afternoon would discuss how important it is for the IBC and what way it can be facilitated. We are conscious of it, the government is conscious of it. The thing is that how fast, how effectively it can be brought in. Thank you very much, ladies and gentlemen.
Thank you very much, Dr. Ashok Haldia, sir, for your kind enlightening words and sharing your knowledge. Ladies and gentlemen, there is a reordering, and on request, permission to my request basis, as Justice Mishra sir has to start his process of hearing in some arbitration. So I would be at privilege and honor to invite him before Justice Mida sir. So I may request Honorable Chief Guest to please address and enter it into our.
I would suggest Justice Mida to speak first, and I will speak. I sitting at the record.
Thank you so much, sir, for your. Thank you so much for your consideration, sir. Thank you so much. Now I would like to request and invite our guest of honor, Justice J.R. Mida, former Judge, Delhi High Court, to please come and enlighten to our address. Ladies and gentlemen, please give a huge round of applause.
Honorable Justice Deepak Mishra ji, Mr. K.K. Sharma, Dr. Ashok Haldia, Mr. Basudev Mukherjee, Mr. Raman Agarwal, and all the participants here. At the outset, I convey my thanks to the ASSOCHAM for inviting me on this platform to share my views on the ADR. I also compliment for choosing a very attractive topic. Name is very nice, ease of justice in India. Whosoever has coined it, it is very nice coined term. And in fact, the ADR is there to ease the justice system. You see, you all are aware that in courts, because of the number of cases, it takes a huge time. And because of those delays, we are looking for this alternative dispute mechanism. And if you see, in the last 10 years, the ADR law has developed so fast, which no other law has developed. And two reasons are there for development of this law. One is that most of the disputes on this basis are commercial contracts. So there the money is involved. So therefore the economy is based on it. So if there is a judicial delay and we are not able to do justice in time, it will affect the economy of the country. And secondly, the law in the developed countries have developed so fast. And then there was also pressure from the developed countries as well as the business community that they will come to India only if there is a fully developed law of ADR here. So with that thing in mind, so Arbitration Act, if you see Arbitration Act 1940 was so primitive law and had almost choked the arbitration in the country, that with the 2015 amendment it became so developed, and then 19 amendment it went further ahead, and then with the Supreme Court judgments, the law has further developed so fast, and the most important judgment is Parkin's judgment. You see what was happening earlier, that the Arbitration Act agreement provided that one party can appoint an arbitrator, and that was held to be valid, and that arbitrator was invariably not impartial. So therefore the entire impartial award would come. So the Supreme Court in Parkin's judgment said that henceforth, even if the agreement provides that a party can appoint an arbitrator, no party can appoint an arbitrator. It is only the court which will appoint. So major change in the arbitration jurisprudence came with the Supreme Court judgment, that now where the parties lose the right to appoint a sole arbitrator, it is only the court which will appoint a arbitrator. So that is one major change which has come in the recent times by the judgment. And then major change which came with the 2015 and 19 amendment is, earlier there was no time limit. Now they have fixed the time limit. Within 6 months the pleadings have to be completed, and within 1 year the award has to be passed. Then earlier there was no cross and check on the arbitrator. Now the arbitrator is required to give a declaration that how many arbitrations he is conducting and whether he is in a position to complete the arbitration within the time frame. So that makes a major change. And then again there was earlier the fees was an issue. Now there is a limit of fees also under the schedule to the Arbitration Act, which makes the situation more convenient for the litigant. So to my mind, in the last 10 years, the arbitration law has developed so fast and is almost now mature, and you can say it has reached a very optimum level where we can deliver. The question rises, what is the difference between arbitration and litigation in court, adjudication in court? There are various differences. One, of course, is that they get a convenient platform. You don't have to wait. You get it in time. Other things are there, but I will deal with only one issue. You see, it is well settled that when the arbitrator gives an award, under section 34, when the objections are filed, the scope is very narrow. Rule is, we should not interfere with the award. Even if two views are possible and the other view was better than what view arbitrator has taken, still the law is that you cannot interfere with the award. So, and the 34 is not like an appeal. It is a very, very narrow. This all of us know. Now I am giving you another angle. On one hand, we have narrowed down the scope. On the front gate is so narrow it is difficult to enter, but 34 opens another gate at the back. Section 34 says that, explanation to 34, that if the award is against most basic notions of justice or morality, then it can be set aside. So, question rises, what is justice and morality? It is not defined anywhere. So then, in Associate Builder's case, the Supreme Court Justice Nariman interpreted justice and morality and said these words have not been defined. Normally, morality is seen with moral turpitude, but here in commercial context, that is not the issue. So, most basic notions of morality of justice means which pricks the conscience of the court. Now, I'll take you further. If a civil court passes a judgment and decree, the appeal under section 96, the appellate court has all the powers which they had got which the original court had got. But the appellate court is not empowered to go into the morality. They have to see only the legality. So let's assume a counsel raises a point that, look, this award is against, this judgment of a civil court is against morality and justice. So court will say that you please restrict to the legality, not morality. But in arbitration, although the scope is very narrow, but the court is also required to look into morality. Now, all of you must be wondering about the meaning of this technical term. I'll give you a very live example. 2 cases came before me. Although an associate builder, they interpreted what is pricks the conscience. But prior to associate builder, a matter came before me in which Kotak Mahindra Bank took a property on lease. Rent was about 10 lakhs on a long lease. After 3-4 years, the rent in the area fell down. So the bank approached the landlord that, look, the rents have fallen down to half. So either you reduce the rent or we'll vacate and take the adjoining property. So landlord examined and he said, all right, rents have actually fallen. So we will reduce the rent from 10 lakh to 5.5 lakhs. So supplementary lease deed was executed. So bank started paying 5.5 lakhs. After 3 years, the landlord issued a notice that please pay me according to 10 lakhs. And then invoked the arbitration. Matter went to arbitration of a former judge of Allahabad High Court. So landlord took the plea that, look, first of all, I didn't agree to reduce. Secondly, that document which they are relying is not registered. So unregistered document cannot be looked into. Law is well settled. Unregistered document cannot be looked into. So the arbitrator gave an award that this document I cannot look into, therefore you pay 10 lakh rupees. Now when the objections filed and they came before Delhi High Court, I took the view that number one, this award is against morality. You are a dishonest person. You reduce the rent from 10 lakh to 5.5 lakhs. You signed this document and now you want to encash upon it. So I'm giving you the difference between legality and morality. And secondly, you have made a false statement here on oath that I never agreed. You have agreed. You have signed that document. You are taking a defense of non-registration. So that I am issuing a notice under 209 why you should not be prosecuted for raising a false claim. And the matter was settled. So I didn't get an opportunity to write a judgment. This was prior to associate builders. Then second case came before me recently in 21 before my limiting office, where a person took an institutional loan and out of that institutional loan 38 lakh rupees remain unpaid. The interest rate was 3% to be compounded every month. By compounding it every month, 38 lakh rupees became 90 crore. So arbitrator gave a award of 90 crore. When the objections were filed, it came, I said it is against morality, most basic notions of morality and justice. Even a common man, even I may have 38 lakh rupees unpaid, but can I pay 90 crores? I should notice to the government also, what is your duty? Cannot there be any restriction? This used to happen in the villages when a poor person will take loan and the Zimidar will take paper signed that if you don't pay within 1 month, your entire land and everything will become mine. So I said, and the other side was willing to pay 36% simple interest, which came to about 3 crore. So although final judgment I have not yet given, but the interim order which I had passed, I said this prima facie appears to be against most basic notions of morality or justice. The matter is still pending in division bench and then the law will be settled by Supreme Court. But what I am taking you, that arbitration scope of 34 is very narrow, but one area which opens a floodgate where you can look into morality also. So this is a plus point. Now I go to the third thing, which is mediation. In mediation, the first thing to be seen is the morality. I'll give you a live example. Let's assume a person has given a loan of 10 lakhs and other person is not paying it. If the matter goes to the court, the defendant will raise 100 technical objection that look, it is barred by limitation, this is not registered, this is not there, this is not there, and court will have to deal with all that and look into law. But if the matter goes to the mediator, so mediator you can't raise those technical things. He will only ask 2 questions, भी आपने पैसे लिए हैं और आपने दे दिए हैं. वो कहते नहीं दिए तो क्यों नहीं देते, भी पैसे दे दो, थोड़े कम दे दो, खत्म करो, इंटरेस्ट कम कर देते हैं. So, and what is this? This is only morality, no? कि भी आपने पैसे लिए तो क्यों नहीं देते? या एक टेनेंट खाली नहीं कर रहा तो कहेंगे तुमने किराए पे लिया था, क्यों नहीं खाली कर रहे? किराया भी नहीं दे रहे, खाली तो करो. So arbitration where we go legality and morality both. Court we only go legality. In mediation we go totally first on morality. And then one more major difference. When the matter goes to the court or arbitration, you have to go by the pleadings. Court can't go beyond the pleadings. कोर्ट ये नहीं कह सकता भाई ये वाली तुम बताओ असल क्या बात थी जो आपने लिखी है. They can't ask. Counsel can say that, look sir, this is the plate, this is the written statement, you go by law. But in mediation, you go behind the scene भी कि झगड़ा क्यों हुआ, भी क्यों पैसे क्यों नहीं दे रहे आप. वो रियल फैक्ट फिर सामने आएगा जो मीडिएटर देख सकता है और देख के उसका सोल्यूशन निकाल सकता है. नंबर 2, मीडिएशन के अंदर जो सोल्यूशन होगा वो दोनों को एक्सेप्टेबल होगा, उसकी कोई अपील नहीं है. नंबर 2, दोनों जने सेटिस्फाइड होकर जाएंगे. और एक जो और मेजर जो डिफरेंस है मीडिएशन में कि सोल्यूशन इन द मीडिएशन में बी बेटर देन द सोल्यूशन विच यू कैन गेट इन कोर्ट्स. इसका एक बहुत अच्छा एग्जाम्पल जो बहुत बार मैं शेयर करता हूँ, मेरे ख्याल आप सबने सुना होगा. ये वो आदमी जो है उसने बहुत गरीब आदमी था, मदर उसकी ब्लाइंड थी, बच्चा नहीं था, तो वो बहुत भगवान शिव की पूजा करता है. तो एक दिन भगवान शिव आ जाते हैं और वो कहते हैं भाई मांगो, एक वरदान मांग लो. उसने कहा मुझे थोड़ा टाइम दो कंसल्ट करने के लिए, अगर एक ही देना है तो मदर से पूछता है तो मदर कहती है मैं ब्लाइंड हूँ, मेरी आंखें मांग लो. वाइफ कहती है भाई ये बुढ़िया तो मरने वाली है, इसकी आंखें की क्या जरूरत है, बच्चा चाहिए हमें तो. और गरीब आदमी कहता है खाने को नहीं है. तो वो घर में बहुत झगड़ा फसाद हो जाता है. फिर भगवान शिव आते हैं, कहते हैं एक दिन का टाइम और दो. फिर वो मीडिएटर को कंसल्ट करता है, किसी सियाने आदमी को कंसल्ट करता है. और सियाने आदमी को कंसल्ट करके फिर वो भगवान शिव को कहता है जी ऐसा है, मैं चाहता हूं मेरी माँ मेरे बेटे को सोने के कटोरे में चावल खाते हुए देखे. तो मीडिएशन में जो सोल्यूशन निकल सकता है वो आर्बिट्रेशन में और कॉन्सिलेशन में नहीं निकल सकता. और आर्बिट्रेशन में जो मोरालिटी का जो पॉइंट है वो कोर्ट में भी अवेलेबल नहीं है. तो तीनों चीजों का, और मेरे विचार से जो अब ये नया बिल आ रहा है जिसमें प्री लिटिगेशन मीडिएशन मैंडेटरी हो जाएगी, ये बहुत अच्छा है. इससे अगर इसको बहुत ऑनेस्टली किया जाए तो आधे केस जो है वो, आधे नहीं तो 40% केस जो है वो सॉल्व हो जाएंगे. तो जुडिशरी का बर्डन कम हो जाएगा. आर्बिट्रेशन तो तब शुरू होगा अगर आर्बिट्रेशन एग्रीमेंट है. तो ये सारी चीजों को मिलके अगर हम चलाएंगे तो मेरे ख्याल से जस्टिस, ये जो इनका टाइटल है ईज ऑफ जस्टिस इन इंडिया, ये बिल्कुल इसका साक्षात्कार हो जाएगा. पर एक और पहलू जो बड़ा इंपॉर्टेंट है कि अल्टीमेटली जो है जस्टिस डिलीवरी सिस्टम का जो ऑब्जेक्ट है दैट इज टू मेंटेन पीस इन सोसाइटी. एंड टू फाइंड आउट जस्टिस करने के लिए यू हैव टू फाइंड आउट व्हाट इज ट्रूथ. एंड ट्रूथ कैन नॉट बी फाउंड बाय आर्गुमेंट्स अलोन. अगर मुझे डिसाइड करना हो कि इस लिक्विड का टेस्ट क्या है इस बॉटल में, और एक जना कह रहा है जी मीठा है, कह रहा है नमकीन है, अब मैं चाहे बहस 1 घंटा सुनूं, 1 दिन सुनूं, 1 साल सुनूं, 100 जजमेंट पढ़ लूं, उसका आंसर नहीं निकलेगा. जो भी निकलेगा वो गलत हो सकता है. ओनली वे इज टू टेस्ट इट. इफ आई टेस्ट इट देन ऑल आर्गुमेंट्स बिकम इरेलेवेंट. तो सच तक कैसे पहुंचना है उसकी बहुत टेक्निक्स हैं. चाहे वो आर्बिट्रेशन हो, उसमें भी हमें सच तक पहुंचना है जस्टिस करने के लिए, अगर परफेक्ट जस्टिस करना है. और अगर आर्बिट्रेशन है तो भी सच तक पहुंचना है. और अगर हमें मीडिएशन करना है तो भी सच तक पहुंचना है. सबसे पहले बताओ भी सच क्या है. एक बड़ा छोटा सा एग्जांपल मैं दूंगा बिफोर आई क्लोज. जस्टिस मिश्रा को भी मैं वेट करवा रहा हूं, मेरा टाइम हो गया. एक आर्बिट्रेशन का मैटर आया जिसमें एक 80 साल की विडो डॉक्टर लैंड लेडी ने केस फाइल किया. उसने कहा जी मैंने किराए पे जगह दी थी डिफेंस कॉलोनी में बेसमेंट 3 साल के लिए, और 3 साल पूरे हो गए, 5 साल हो गए, ये ना तो किराया दे रहा है ना खाली कर रहा है, और 35 लाख रुपए किराया ड्यू हो गया. तो इसमें आर्बिट्रेशन क्लॉज है, आप आर्बिट्रेटर अपॉइंट कर दीजिए. अब ऐसे केस में नॉर्मली हम नोटिस इशू करके आर्बिट्रेटर अपॉइंट कर देते हैं, कोई ज़्यादा कोई कॉम्प्लिकेटेड काम नहीं है. और नॉर्मली 1-1.5 महीने का नोटिस की तारीख लगती है पहले. तो शाम को जब मैंने फाइल पढ़ी तो मैंने कहा बहुत बेईमान टेनेंट है जो ना तो पैसे दे रहा है, ना किराया दे रहा है, ना खाली कर रहा है. तो मैंने कहा इसमें शॉर्ट डेट दस्ती नोटिस 1 हफ्ते का जारी किया और उसको कहा कि तुम दस्ती सर्विस करवा लो. 1 हफ्ते बाद जब टेकअप किया तो उन्होंने कहा जी ये बाहर गार्ड खड़ा है, वो अंदर जाने ही नहीं देता हमें दस्ती के लिए. तो फिर मैंने SHO डिफेंस कॉलोनी का मैंने कहा सर्व करो, और टेनेंट को कोर्ट में आए पर्सनली. 3 दिन बाद लगा लिया, तो लॉयर आ गया, उसने कहा जी मैं आ गया हूँ, आप आर्बिट्रेटर अपॉइंट कर दो। मैंने कहा पहले टेनेंट को तो बुलाओ एक बार, देखें तो सही, ना किराया दे रहा है ना खाली कर रहा है, ये तो बहुत बेईमान आदमी है। मैंने कहा कल उसको बुलाओ एक बार। तो अगले दिन टेनेंट आ गया, तो मैंने कहा तुम खाली भी नहीं कर रहे, पैसे भी नहीं दे रहे, कम से कम खाली ही कर दो, पैसों के लिए आर्बिट्रेटर में लड़ लेना। उसने कहा नहीं, मैंने 17 लाख रुपए लैंडलेडी को कैश में दे दिए, अलग अलग डेट्स पे, मैं स्टेटमेंट लाया हूँ पर इसने रसीद नहीं दी। तो मैंने लैंडलेडी से पूछा, उसने कहा जी मुझे एक नया पैसा नहीं मिला, शक्ल ही नहीं देखी, घुसने नहीं देते, गार्ड बैठा है। मैंने कहा चलो कोई बात नहीं, 17 तुमने दे दिए, बाकी 17 कहाँ है? कहते जी इस लेडी ने मेरे कजन ब्रदर के नाम एग्रीमेंट टू सेल कर दिया है, बेचने का बेसमेंट का, और 17 लाख कैश उससे ले लिए। तो लेडी से पूछा, उसने कहा जी मैं तो कभी मिली ही नहीं इनको। तो मैंने कहा अच्छा भी वो एग्रीमेंट कहाँ है? कहते वो तो मेरे कजन पे है। मैंने कहा उसको बुला लो कल। मैंने कहा सेक्शन 165 एविडेंस एक्ट में एक कोर्ट कैन एग्जामिन एनी पर्सन वेदर ए पार्टी और नॉट at any stage and ask any question whether relevant or not, provided that the judgment shall be based on facts declared by the act to be relevant. तो मैंने कहा कल उसको बुला दो, कोर्ट कैन एग्जामिन हिम ऑल्सो। तो अगले दिन उसको बुलाया, वो चंडीगढ़ से आया, एक बहुत बड़ा सरदार। तो मैंने कहा भी तुमने एग्रीमेंट किया? हाँ एग्रीमेंट किया। उसने एग्रीमेंट दिखाया, उस लेडी को पुटअप किया, उसने कहा जी मेरे तो साइन नहीं है। तो सारा सुनने के बाद मैंने कहा भी ये तो फॉर्ज्ड लग रहा है। वो कहते जी ऐसा है, हम तो स्पेसिफिक परफॉर्मेंस का दावा फाइल कर रहे हैं, तो आपको तो उस इशू में जाने की जरूरत नहीं है, आप तो आर्बिट्रेटर अपॉइंट करो। मैंने कहा भाई ये फॉर्ज लग रहा है, तुम बेटर है खाली तो कर दो कम से कम। कहते नहीं जी नहीं, हम कोई खाली वाली नहीं, ना पैसे देंगे ना खाली करेंगे, आप तो आर्बिट्रेटर अपॉइंट करो। तो मैंने फिर ओथ पे उन सब की स्टेटमेंट लिख ली। लिख के जब कोई चारा नहीं बचा एंड दे वर ऑलमोस्ट बुलिंग द कोर्ट, मैंने कहा कोई ऑप्शन नहीं है। बिल्कुल मैं खड़ा हो गया कुर्सी से, 4 बजे का टाइम था। तो मुझे अंदर से इंट्यूशन हुआ कि एक सवाल और पूछा जाए, ये तो सीरियल क्रिमिनल लग रहे हैं, ये तो इस तरह से वीक लैंडलॉर्ड कहीं ढूंढते होंगे और हर एक के साथ यही होगा भी एग्रीमेंट बना लो और कैश का रेंट दिखा दो। तो मैंने कहा भी वापस आओ, ओथ दोबारा लो, एक एक सवाल और पूछेंगे। मैंने कहा तुम्हारे ऊपर कितने सिविल क्रिमिनल केस आज तक या FIR चली हैं, कितनी आज पेंडिंग है? तो जो अभी तक जो इतना वो घुरा रहे थे, वो उस सवाल पे वो तो 3-4 मिनट लग गए। 3 मिनट बाद कहते जी एक सेक्शन 138 का मैटर है और कोई मैटर नहीं है। मैंने कहा ठीक है, लिख लिया जवाब। फिर दूसरे को बुलाया, उसने भी 5 मिनट ले लिए। फिर उसने कहा जी कोई केस नहीं है। मैंने कहा बिल्कुल ठीक है, वो लिख लिया। तो मैंने कहा कल 2:30 बजे लेंगे, और मिस्टर राहुल मेहरा सीनियर स्टैंडिंग काउंसिल थे दिल्ली पुलिस के, उनको मैंने कहा जी इनके पुलिस स्टेशन से वेरीफाई करवाओ, दिल्ली और चंडीगढ़, क्योंकि मुझे तो लग रहा है ये तो सीरियल क्रिमिनल्स हैं। तो जब मैं उठ के अंदर गया, थोड़ी देर उन्होंने कोर्ट मास्टर कहा जी मैटर टेकअप कर लो, ये तो सेटल कर रहे हैं हम। मैंने कहा अब नहीं टेकअप करेंगे, अब तो कल टेकअप होगा। अगले दिन 5 FIR की डिटेल आ गई। अगले दिन 5 FIR आ गई। मैंने कहा अब मैं कस्टडी में ले रहा हूँ, तो झूठ बोल दिया तुमने। वो कहते जी हम चाबी ले आए हैं, 5 लाख का ड्राफ्ट ले आए हैं, बाकी 30 लाख की 3 महीने की किस्तें ले आए हैं और अनकंडीशनल एपोलॉजी टेंडर कर रहे हैं। तो मैंने कहा भाई मैं सेक्शन 11 में, हालांकि बड़ी देखो लिमिटेड जुरिस्डिक्शन होती है, 11 में आपने सिर्फ एग्रीमेंट देखना है और डिस्प्यूट देखना है। ऑलरेडी आई हैड गॉन बियॉन्ड द कॉल ऑफ द ड्यूटी। तो मैंने एपोलॉजी एक्सेप्ट कर ली, 2 लाख की कॉस्ट डाल दी, तो उसको चाबी दे दी। 17 दिन में उसको पोजेशन मिल गया और पूरे पैसे मिल गए। दिस इज मीडिएशन थ्रू कोर्ट एंड सर्च फॉर ट्रुथ बाई कोर्ट। एक छोटा सा और एग्जाम्पल शेयर करूंगा। आई एम नॉट गोइंग इनटू कॉम्प्लिकेटेड प्रोविजंस, इट विल। एक केस स्पेसिफिक परफॉर्मेंस का आया, जिसमें जो है प्लेंटिफ ने 4 करोड़ में जगह खरीदने का सौदा किया और पूरे 4 करोड़ दे दिए, और डिफेंडेंट ने वो जगह किसी और को 5.25 करोड़ में बेच दी। तो प्लेंटिफ कोर्ट में आया, उसने कहा जी मैंने 4 करोड़ पूरे दे दिए, ये एग्रीमेंट है, और इसने किसी और को बेच दी, उसको भी पार्टी बना लिया, और कोर्ट ने पहली डेट पे स्टे दे दिया। स्टे तो बनता ही था। तो बहुत हियरिंग बाद जब मेरी कोर्ट में आया मैटर, तो वो जिस लेडी ने खरीदा था नंबर 2 5.25 में, तो वो कोर्ट में आगे रोने लगी। उसने कहा जी आप 165 में एग्जामिन करके सच निकाल लेते हो, इस केस में मेरे साथ इनजस्टिस हुआ है, तो आप पार्टीज को एग्जामिन करके ना इसमें सच तक पहुंचो। तो मैंने प्लेंटिफ से पूछा, उसने कहा मैंने तो पूरे पैसे दे दिए। तो मैंने डिफेंडेंट को कहा भी जब तुम्हें पूरे पैसे मिल गए तो तुमने क्यों बेचा 5.25 में? उसने कहा जी हमारी तो वो डील कैंसिल हो गई और इसको मैंने 4 करोड़ वापस रिटर्न कर दिए थ्रू बैंक ट्रांसफर। प्लेंटिफ कहता जी मुझे नहीं किए, ये किसी और राशि एंटरप्राइजेस को कर दिए और वो इन्हीं की कंपनी है। डिफेंडेंट कहता जी राशि तो इनकी कंपनी है, इन्होंने कहा था वहां भेज दो पैसे। तो मैंने कहा फिर तो यही सवाल रह गया, अभी राशि प्लेंटिफ को रिप्रेजेंट कर रही है या डिफेंडेंट को कर रही है? तो मैंने कहा राशि से पूछ रहे हैं। कहते जी राशि तो दुबई में है। तो मैंने फिर DCP क्राइम को बोला, मैंने कहा भी तुम उनसे इंटरेक्ट करो और उससे पूछो वो किसको रिप्रेजेंट कर रहे हैं। तो हफ्ते बाद लगाया तो उन्होंने कहा जी वो उसको वीडियो पे हमने बात की है, फिजिकली तो कर नहीं सकते, और वो कह रहे हैं कि हमने तो डिफेंडेंट के बिहाफ पे पैसे लिए हैं और वो पैसे लेके हमने आके कुणाल टंडन को दे दिए हैं और उसके पास पड़े हुए हैं पैसे अब, और वो इंडिया में है। तो मैंने कहा फिर तो और आसान काम हो गया, टंडन को बुला लेते हैं। तो हमने अगली तारीख में कुणाल टंडन को बुला लिया। जब कुणाल टंडन को बुलाया तो उसके साथ 10 वकील आगे कहते इसको क्यों बुला लिया, ये तो पार्टी नहीं है। मैंने कहा भी 165 में तो किसी को भी एग्जामिन कर सकते हैं, तो इसको एग्जामिन कर लेंगे और तुम्हें तो क्या ऑब्जेक्शन है, पर है क्या केस, कहते पैसे मेरे पास हैं। तो मैंने कहा इसका मतलब ये मनी लॉन्ड्रिंग का केस लग रहा है कि ए ने बी को दिए, बी को दुबई में दिए, बी ने सी को दिए और सी कह रहे मेरे पास अभी पैसे पड़े हैं। तो मैंने कहा भी आप आधे घंटे में आपस में डिस्कस कर लो, कोई सोल्यूशन निकलता है, नहीं तो स्टैंडिंग काउंसिल उसको बुला लिया मैंने, ईडी वालों को। मैंने कहा उसको बुला लो और सबको कस्टडी में लो, ये तो मनी लॉन्ड्रिंग हो रही है। तो 12 बजे से 12:30 के लिए रखा, 12:30 कहते ही सेटल हो गया। मैंने कहा अब बताओ भी सच क्या था, सच क्या था ये तो बताओ। कहते सच ये था कि ये लोन की एंट्रीज थी, कैश और चेक की, प्रॉपर्टी का कोई, प्रॉपर्टी तो वैसे ही बीच में मेंशन कर दी थी, तो प्रॉपर्टी तो लेडी को ही दे दो जैसा 500। ये केस अदरवाइज कितने साल चलता स्पेसिफिक परफॉर्मेंस का, इट वुड हैव गॉन फॉर 40 ईयर्स, और तब भी सच तक नहीं पहुंचते। और कोई भी कोर्ट कहती भी 4 करोड़ का एग्रीमेंट, 4 करोड़ मिल गए तो प्रॉपर्टी दो। तो और एक लास्ट एग्जांपल मैं शेयर करूंगा बिफोर आई क्लोज। आई एम डिटेनिंग जस्टिस दीपक मिश्रा ऑल्सो। एक एनी कमेंट्स, सॉरी, अच्छा, सॉरी, वेरी सॉरी। एक यूएस में सिगरेट की कंपनी है ब्लैक के नाम से, ब्लैक के नाम से वो सिगरेट बनाते हैं और बड़ा सुंदर उनका डिब्बी है, जो ताश के पत्ते, हुक्म के ताश पत्ते की किंग की तरह की एक डिब्बी बनी हुई है। तो वो सिगरेट इंडिया में नहीं थी, तो इंडिया में किसी मुजफ्फरनगर में किसी ने ब्लैक के नाम से और सेम डिजाइन से सिगरेट शुरू कर दी। यूएस कंपनी को जब पता चला उन्होंने केस फाइल किया तो उसने कंटेस्ट किया, और कंटेस्ट करते करते वो 10 साल केस चलता रहा, एविडेंस वगैरह रिकॉर्ड हो गए, फाइनल आर्गुमेंट की स्टेज पे आया मेरे पास। तो फाइनल आर्गुमेंट्स में आया तो वो डिफेंडेंट का वकील कहने लगा जी ऐसा है कि ये फाइनल आर्गुमेंट्स का केस है, 10 साल हो गए हैं, इतने सारे 20 विटनेस एग्जामिन हुए हैं, तो हमने रिटर्न सबमिशन फाइल कर दिए 40 पेज के और 60 जजमेंट फाइल कर दिए, तो 5-6 घंटे आर्गुमेंट में लगेंगे, आप उस हिसाब से टाइम फिक्स कर दो। तो प्लेंटिफ कहता है ये 6 घंटे लेंगे तो मुझे भी टाइम चाहिए होगा 4-5 घंटे। मैंने कहा आप दोनों पहले 10 मिनट अपना ओवरव्यू बताओ भी केस क्या है, तब मैं डिसाइड करूंगा मुझे समझने में कितना टाइम लगेगा। तो उन्होंने केस बताया, तो मैंने उसको प्लेंटिफ डिफेंडेंट को कहा भी तुमने नाम क्यों रखा, कहता जी हमें तो पता ही नहीं था वहां पे ब्लैक नाम की सिगरेट है, तो हमने तो वैसे ही अपनी समझ से ही रख दिया भी बड़ा अच्छा नाम रख रहा है, सिगरेट तो ब्लैक का ही काम है ना, अंदर छाती को ब्लैक करती है, हमने ब्लैक रख लिया। तो मैंने कहा बिल्कुल ठीक है, तो तुमने जो है ये डिजाइन कैसे सेम बना लिया, तुम्हें पता था, कहते जी वो हमारे डिजाइनर ने बना लिया। मैंने कहा तुम कल डायरेक्टर्स को बुलाओ, उसको ओथ पे एग्जामिन करेंगे। तो पर कहते जी एविडेंस हो चुका है, आप कैसे कर सकते हो। मैंने कहा 165 में लिखा है यू कैन एग्जामिन एट एनी स्टेज, मीनिंग दैट बाई स्टेज 1 और स्टेज 10, आर्गुमेंट के बाद भी जजमेंट से पहले अगर मेरे को लगता है कुछ पूछना चाहिए तो भी पूछ सकता हूँ। तो अगले डायरेक्टर आ गए तीनों। मैंने कहा ये तुम्हें पता था ब्लैक नाम की सिगरेट है, कहते जी नहीं पता था। ये डिजाइन पता था, ये भी नहीं पता था। तो किसने बना दिया डिजाइन, कहते जी एक डिजाइनर था उसको दिया, उसने बना दिया। मैंने कहा इसका तो ये डिजाइनर तो भगवान से भी बड़ा हो गया, अगर मैं भगवान को भी कहूँ कि तुम बनाओ बिना देखे तो सेम तो नहीं बन जाएगा। मैंने कहा कल डिजाइनर को बुलाओ, उसको एग्जामिन करेंगे। अब डिजाइनर तो कोई था ही नहीं, वो तो एक प्रिंटर था जिसको दिया था। अब वो शाम को वकील पे गए, उनका डिजाइनर तो कोई है ही नहीं। तो उसने कहा फिर तो फॉल्स स्टेटमेंट हो गई, ये तो 209 में कस्टडी में चले जाओगे। तो फिर वो उन्होंने चेंज किए, सीनियर काउंसिल पे गए, उनका जी 209 में कल भी एक केस में बंद हो गए थे, तो ये तो बहुत झगड़ा हो जाएगा। तो आए अगले दिन, उनका जी ऐसा है जी आप डिग्री पास कर दो, हम कंटेस्ट नहीं करना चाहते। दूसरे ने कहा जी हमें 10 साल रुलाए इन्होंने, यूएस से विटनेस आए, हमारा 1.25 करोड़ तो खर्च हो गया, तो हम तो बिना 1 करोड़ रुपए लिए नहीं सेटल करेंगे। तो उनका जी अच्छा 22 लाख रुपए नेगोशिएट करके 22 लाख रुपए और डिग्री पास कर देंगे
बिना आर्ग्यूमेंट्स के,
नो आर्गुमेंट्स इन 15 मिनट। तो कहने मतलब ये हर केस में इट इज ए सर्च फॉर ट्रूथ, वी हैव टू फर्स्ट फाइंड आउट। और कोर्ट के अंदर बोथ द साइड्स नो द ट्रूथ, बोथ द काउंसिल्स नो द ट्रूथ, एवरीबडी एक्सेप्ट द जज नोज द ट्रूथ, जज इज ऑन ट्रायल टू फाइंड आउट द ट्रूथ, and the law gives sufficient equipment or you can say weapons to find out the truth. Although this was beyond the topic, but I thought it will be more, you will find it discussion exciting. But I am very happy that mediation bill is underway. This conference has been kept at a very good time when mediation bill is underway, when arbitration law has developed so nicely in our country, and I look forward that we will have a fully grown ease of justice in India. Thank you very much.
Thank you very much, Honorable Guest of Honor, for your kind enlightening sharing of experience and your kind words. That is giving us way forward that how as victim or as plaintiff the person can look at the justice. There is also a reason of in the backdrop of this particular theme that we have kept in mind while scheduling this conference and coming out with this. So I will share it later, but before that I would like to request and invite our honorable chief guest, Justice Shri Deepak Misra, former Chief Justice of India, to please come and enlighten to the august gathering over here. Thank you so much.
Justice J.R. Meena, former Judge, Delhi High Court, a dear colleague of mine while I was there, Mr. K.K. Sharma, Senior Advocate, Dr. Ashok Aldiya, Mr. Vasudev Mukherjee, ladies and gentlemen. It pleases me the most to be amongst you, though virtually, as a chief participant to talk on ease of justice, arbitration, mediation, and conciliation. I would like to pose a question. Why discuss area? What's the benefit? What's the gain? It is because all of us have a craving for justice, and that justice which is cost effective, participative, and speedy. Unless these three facets are there, the concept of ADR is not satisfied. All of you must remember there are four categories of personalities. One, who that knocks at the doors of the court, a litigant. Second, the person who advocates his cause in a court of law, the advocate. Third, the adjudicator, who after weighing the materials on record or getting into nitty-gritties arrives at some kind of judgment which is according to law. And fourth, there are people who are bent upon sacrificing and spending time to find a solution to the root cause. I would like to call them the solution seekers. They are eventually the arbitrators, the conciliators, and the mediators. Why is ADR significant? In this context, I would quote two lines from Sanskrit and translate them. Kita, Chinta, Samavakta, Bindusthane, Vishesatah, Sajivam, Dahate Chinta, Nirchivam, Dahate Kita. Every translation of this would be the differentiation between Chinta and Chitta is only that of a dot. And the most significant distinction is that Chinta or worry kills a living man, but Chitta or the fire destroys a dead body or extinguishes a dead body or what you call it remains. This is the worry. A person who enters into a litigation, civil, criminal, commercial, or any nature, unless he is a perverse code bird, he has the worry to efficiently eradicate that worry, that pain to the body. Various modes have been thought of. In 21st century, these thoughts have gained ground both in the other countries as well as in India. Not, I must at this juncture tell you, I was very carefully listening to Dr. Aldia. He was really emphasizing introduction of arbitration, mediation, and conciliation in the arbitration proceedings. My personal view is, in the arbitration proceedings, there can be space and there can be room for mediation and conciliation. There has to be some kind of experimentation with those two concepts in that area, and thereafter the legislatures, with the assistance of the think tank, can conceive the idea of arbitration. It is better we go slightly chronologically, but not take an unnecessary quantum leap. But the idea planted by Mr. Haldia is a welcome idea. Having said that, let me concentrate on mediation. I am not going to arbitration presently. I would like to give an example with regard to mediation. All of you come from different social backgrounds. We are having a Lok Adalat session. There were two couples and two divorce petitions were filed. In course of discussion, it was known that there was exchange marriage. One brother to the other sister to his brother. With that arrangement, it passed 4 persons, but they could not settle. Then I tried to intervene as the chairman. They spoke a kind of language I could not understand much. But one thing they spoke, that we want to reconcile. I see in a Lok Adalat, that's difficult. We can pass it, we can withdraw. But we wanted to close the chapter. So we converted to mediation, which had please change the scenario. Only one person we called the local council who could understand their dialect. He talked to them, I was there, and eventually after 15 minutes, one couple agreed to go, and with some conditions we are written, and that will be signed by the concerned family court judge. That will be decreed. At that point of time, 5 steps the lady had gone. She came and told me, and I am telling it in Hindi, दूध तो बाबू, this is the exact language. दूध तो बाबू चला जाएगा, मेरा भाई का क्या होगा? That was a great point. So we requested the lawyer, please intervene. The other couple must also go together. See, you can't solve this problem immediately. So we give did one thing. We called other two lawyers from that particular village, and they gave us the guarantee to the girl that this boy man will not drink that much, he will moderate his drinks and will not behave improperly. She trusted them, and thereafter the matter was solved. I am emphasizing two aspects: patience, knowledge of the geography, and in addition to that, trust in the people. They were uneducated. They did not know anything about forgery or perjury. They are innocent, but they are victims of the suffering. How to deal with suffering also? Dealing with suffering through mediation is wisdom of the mediation. That is what I would like to tell the members of the ASSOCHAM and today's audience. Mediation must have the quality resolution, and commercial disputes can be resolved and have been resolved through mediation. A civil appeal came before us. It involved 10,000 crores. Various properties at Mumbai, Ahmedabad, Delhi, they are big people. We send it to a mediator, very well established former Supreme Court judge who acted as the mediator. He took 4 months and he submitted a report of 59 pages. Both parties accepted and we made the report as it is a part of the Supreme Court judgment. Lo and behold, after 15 days, an application was filed by one side that we want a correction in this paragraph with regard to this figure. The other side objected. And they said, send it back to the mediator. Look at the trap over here. Once you send it to the mediator, the decree doesn't remain. Then I was compelled to say that look here, you are accepted the report, as your eyes wide open, and we cannot really send it back to the mediator for correction. Accept it and leave it, and live in peace. I told about peace. What is this peace? Everybody says peace is required. There can be no denial. Peace is the essence or the element vital of the human soul. From centuries, the mankind is searching peace. Sometimes they get it, on occasions they get it, and sometimes they don't get it because of their own conduct, their own obstinacy, and their adamant attitude. This is not individual peace. If the success comes in a litigation, whether it is individual litigation or some kind of community litigation, it brings collective harmony, collective peace, and societal equilibrium or societal stability. When societal stability comes, you must understand, in society, an atmosphere is built where peace gets embedded and economy of the society gets further fostered and nurtured. There is progress, there is growth. Success in mediation brings a good governance. Is there anyone in the hall who can question good good governance. That good governance is not a warranted concept in a democracy. In every democratic body politic, this is necessary. Unless such a society, good governance is there, you cannot have progression. On the contrary, you will move on the path of regression. That is why the mediators have to be qualified. They have to have opposite training. They have to be they have to have that kind of commitment which is wedded to the idea of sensitivity and sensibility. And they must know the law of that particular dispute related to the controversy. Unless they know the law, the parties will not have trust in them. And remember, in every litigant, there is an innate desire, unless, as I told you earlier, is a convert litigant, that somebody elderly, somebody non-knowing, somebody empathetic, somebody sympathetic, and someone who can pacify us, somebody who can do justice, somebody who can ameliorate our disturbances, who can bring in amity between us. A desire is there. So you have to choose the right person to come in and solve their agony. Once the agony of litigation is solved, let it be individualistic litigation or a company litigation, I've always maintained there will be intergenerational growth, intergenerational amity and harmony. The win-win situation all of us talk about, it's indubitably the conception behind a social stability and in the presence of a well-established mediator. That is why I always say mediation training has to be up to date and rigorous. Having said that, I would like to give a simple example. I use the word empathy. I do not intend to describe the meaning of the word empathy. Empathy is much broader, keener, and more human than sympathy. In empathy, you get into the position of the other. You feel. See, it was a motor accident case. The man had suffered from amputation of 2 legs, both above the hip joint. He was sitting there. You know, that was a local adalat, a judge and an advocate, a social worker are members. When we entered, the man could not get up. His case was not taken up till lunch. After lunch, his case was the first case. There are many people present. You know what he told? साहब, मैं उठ नहीं सकता, माफ कीजिएगा. I told him, you don't have to feel sorry. We have to feel sorry, but we have to wait because the other side is taking some kind of instruction. I may tell you, Upadalat is not your subject, but we converted that to a kind of mediation. And we requested all the counsel and the parties to leave for 5 minutes. And they left. Then we called the insurance counsel. I said, please look at him. His plea was that the man is not suffering from total permanent disability. I said, what is this total disability, permanent disability? Look at him. I gave him an example. There was a war field. The people were carrying dead bodies. Once they carrying a dead body on a stretcher, the man said, "Hey, why are you carrying me? I am alive." He said, "Forget it. There is a stamp on your forehead by the doctor that you are dead. How can you keep me alive?" I said, "You can't behave like that. He really can't walk. And I don't think that he will be able to fit with artificial limbs so easily." So eventually, on agreed terms, in though the 2004, he was given, I think 16 lakhs. It's not an amount he said that much. It was settled. The culture of settlement in any area, family dispute, insurance dispute, commercial dispute, I will say, is most welcome, and that will be the fundamental vitality of peace, of justice in this great country. Now, coming to arbitration, in 2018, while the Law Minister of Singapore was here and I was addressing, definitely the Law Minister of that country spoke about what they have done. I say India is not far behind. Within a short span of time, India is going to be the hub of arbitration. And India has progressed. See, the motto of the jurisprudence, which the apex court adheres to, lists or minimum interference and maximum acceptance. You do not interfere with an arbitral hour. Just like that. There are good reasons for interference. So that the arbitration gets the ground and people also have the faith in the arbitration and also in the process of non-interference by the court. You see, there is some kind of quarrelsome time that in other arbitration or institutionalized arbitration in our country, it takes time. It goes beyond a year and a half. There is no dispute. Sometimes the extension is for 6 months or another 3 months. But everyone, and I mean everyone, is conscious that I have to be guided by this period of limitation imposed or prescribed by the statute. And the parties do not seek adjournment unless there is difficulty. 4 years back, I had told in a meeting, if the lawyers and the parties stop seeking adjournment in courts and quasi-judicial proceedings, as well as other non-statutory tribunals, there will be reduction of pendency and reduction of cases. Now, mediation bill is going to be an act. Everybody is keenly waiting for it, because where the decision will be executable like a decree, and there is focus on the pre-litigation mediation. And I'm very happy to say there is a provision that period is excluded from prescribed or the prescriptive limitation. And I'm sure with the people like you working in the field, we will graduate mediation to a post-graduation level, and people will follow the path of mediation. Conciliation, though, is there in the Arbitration and Conciliation Act 1996. I must tell you from my experience, it has really not taken any kind of leap. There are some conciliation taking place, but conciliation as they are, it's not becoming that workable because of the attitude of the parties sometimes and also sometimes with the lack of presence on the part of the conciliator. People are to be made aware about conciliation and mediation. I am not saying that people should be made aware of arbitration, but there are lawyers and they know how to do it, and they also know what the law and what's the prescription. But once people know about mediation and conciliation, and I am absolutely hopeful that each of justice in this country will have a quantum leap. Before I part, I must congratulate ASSOCHAM for organizing this kind of workshop, and I must thank the co-panelists to have given absolutely considered ideas, and that should be also adopted and followed in further sessions, and that should be also kept in mind. Thank you very much.
Thank you very much, Honorable Chief Guest, Guest of Honor, and Advocate K.K. Sharma, our special guest, for your kind words and sharing your experience. Indeed, I am only the person who has nothing to do with law. I am not a law graduate, but I am simply learning the law from luminaries like you all people over here in the on the dais, and I would just share with you how this topic of ease of justice in India was decided and scheduled for this conference. Will take a minute time only with your permission.
Yes.
In fact, I was just having a case in UP RERA against one particular builder, and I was struggling to get the justice delivered, but it was not being done so. I spent almost 1 year time, right? And there were almost, I was the first only the customer with that real estate builder who, applied with this case in the UP RERA. And then what happened, there were my fellows who started filing case in UP RERA. But the justice was far away. Hardly it was being expected by me, at least. So after 1 year's time, almost during this pandemic, the order was given by the member in the court, and then I started hopefully positively that I will be getting my refund back. But again, 8 months' time was already over after the judgment order. And then I tried to find out why this is happening, and I started writing on social media platform of UP RERA. So I would just share with that how, and is there any possibility whether the court can be influenced? Is there any possibility? But yes, if the truth lies that with you, then you can, to my understanding, what I have learned from. So then I found in the response that the UP RERA replied that Mr. Parashar, since your order judgment was given, but unfortunately the order case number was wrongly mentioned. Order was given, but case number was wrongly mentioned. So you need to again apply with request under section 39 that this should be rectified. And then I found that the honorable member who gave the judgment, he was on some messenger, Facebook messenger, and I simply requested him, finding that he has written a very good book. He wrote a book on relevance of God in modern age. So with honor and request to him, I just wrote a message to him, sir, is there any relevance of God and UP RERA? I am referring to your case with due honor that the judgment I have received, but 8 months' time is already over, and then I have come to know that judgment order was carrying the number which was wrongly mentioned. So whether I am at mistake, UP RERA is at mistake, and who is at privilege of just delaying further and deferring my payment which is overly due. And then he replied in the messenger, thankfully, and then he said, can you come to my office tomorrow? Yes, I availed the leave and went out to his office. He got one application signed from me, and immediately he ordered to get it done. So thankfully, then rectification was done. Then I gave the call to the lawyer of the that particular builder that this is done. The lady said that no, this was not done. मैंने कहा this is the copy of order with me. So in a way, I could thankfully maybe that the request was considered by the court, and I got this happened. And then finally, again, the payment was not being done. In likewise, in our other case, almost 800 such applicants are already fighting. But thankfully, the person who is sitting here, Mr. Venkat Rao, he was the one who came with the solution for with the mediation, and he helped me to finally get this particular refund in my account. But this is due to only the mediation. So that's the power that I could realize, fortunately, out of 800 such customers. And coming to the essence of this theme, this ease of justice, I thought that this lies in all such commercial matters which are of prime importance to the corporate members of ASSOCHAM as well. And if we talk the essence, that time and cost both are very important. Cost, to take the cost perspective, we have got Jupiter's Justice. They are here, they are fantastically, they are working on technological aspect, and they are making it faster that how the justice can be delivered. I would also share with your permission 1 minute, sir, that I took the opportunity of working with one of the important entity under central government body. With my learning and insights on the learning of the finance subject particularly, and having taught the subject of finance for almost 13 years in management institution, my sixth sense, gives me some sort of auditability of the accounts, and I could find in that records that the particular department where I was working was having a lot of corrupt practices. And I brought to the notice of my senior, who was bureaucrat, and then informed that, sir, this is something which is big happening over here. And then what did he do? He, within 15 days time, he just, what did he do? That he made the person who was in question of mine, my boss. That fellow became my boss for leave sanctioning purposes even. So then I started struggling and applied 3 times at least for resignation, but I was not being relieved. As soon my 1 year time completed, I availed. I wrote in the letter that please, with immediate effect, now my tenure is over, so I am just resigning from here. And then I requested that please give me the NOC and the experience certificate. They did so within 10 days time. And then ultimately, then later on, I requested to please clear my dues, because experience certificate could have been otherwise. So this is something which I have been learning from experiences and practices that the luminaries, they are sharing likewise in this kind of the conference. So I learned, and then I got the experience letter and the NOC in my hands. And then, but the salary was not being paid. So I then said that, is this the fair practice within the institution which is so-called for the good governance, which is teaching to the people in the country the good governance subject, but my payment is not being done, and the corruption is prevailing over there. Then finally, what did follow? The one Supreme Court lawyer sent me 3 times notices mentioning the defamation case on me for 1 crore charges or unconditional apology. Then with all experience, the person who is sitting also here, I may reserve not to mention his name if you allow, then he guided me what can be done. So then I just replied in that notice that they asked me what are the evidences you are having in possession to please share. I said simply, if I say that I am carrying some evidences, then I may be held responsible that these evidences were not supposed to be brought back to at your home. So I simply mentioned in reply that since I did not carry any evidences, but what can be done, I will come along with media cameras, and those evidences can be produced lively, so give the opportunity to present in front of the country. So they can be, knowing this all about what the corruption is prevailing. And then suddenly they stopped communicating anything, but they did not pay my salary. So, but I think with, if law permits me, I am at higher side, and I can learn from the ways forward that how can I demand further, which is for my salary, which is still outstanding on their part. due on their part. Going forward now, I will not take much time. We'll keep learning more and more on these practical life experiences from people like you. Would request Mr. Vasudev Mukherjee, Assistant Secretary General, to please come in and propose the vote of thanks.
Honorable Chief Justice Deepak Mishra, former Chief Justice of India. Guest of Honor, Justice Shri J.R. Midha, former Judge, Delhi High Court. CA Dr. Ashok Haldia, Chairman in Indian Institute of Insolvency Professionals of ICAI. Advocate K.K. Sharma, Chairman, ASSOCHAM National Council for Arbitration and Mediation. It is indeed a privilege to be amongst all of you and for proposing the vote of thanks. It is extremely useful to have learned from the luminaries and practicing professionals who have shared their experiences and thoughts on the subject of recent trends and challenges in the existing framework and the ecosystem of arbitration, mediation, and conciliation. I am sure that the subject experts in the technical session will further add more to the deliberations and share how and what more needs to be done in the field of ADR. The online dispute resolution policy for India is paving the way for a brighter future for dispute resolution in India. India has a lot more work to be done to map the gaps in connection with ODR legislation as well as technology usage towards supporting a faster mechanism for ADR services. The efforts being made by the government towards infrastructure and technology-enabled environment to indicate a positive response to the required faster delivery of justice. The adoption of legal technologies is welcoming, however, its promotion and awareness is equally more important. At the time, a focus on and cautious approach to minimize the risk associated with integration of technology in dispute resolution is the need of the hour. ODR has not yet reached the level of success, but is definitely on the right path to clear obstacles of cybersecurity and technical awareness. On behalf of ASSOCHAM, would like to sincerely thank the Chief Guest, Honorable Justice Deepak Mishra ji, former Chief Justice of India, for making it convenient to address this august audience for at this conference. I am gratefully thankful to the Guest of Honor, Justice Shri J.R. Midha, for your kind acceptance and taking time out to address the august audience. I would also like to thank CA Dr. Ashok Haldia, Chairman in Indian Institute of Insolvency Professionals of ICAI, for his special address. We are thankful to the Council Chairman, Advocate K.K. Sharma ji, for your guidance and support in organizing this conference. On behalf of ASSOCHAM, I would like to thank all of our esteemed guests, speakers, delegates, and partners who have extended support in organizing this conference. I hope the deliberations of this conference would be useful for all the stakeholders of industry, policymakers, and academia attending this conference. Thank you very much.
With permission, though we apologize for the time that we have stretching across. But may we have any question that you have to our guest of honor or maybe to chief guest? Only one question to each. Please be seated, sir.
President of AIHDR, first of all, I congratulate you. You are reviving the AIHDR. Now, what I see in the forum, we are service providers. The consumer is not there. What we have to do is to tell the businessmen that we are going to serve you. How somehow the other bring businessmen into it. Not even one comes to the meetings. So this is one important point. But along with that, just as Midha mentioned, on justice, morality. Now our question is, India lacks both these things. We are internationally known for that. So we should concentrate in that direction also, so that we improve our index on that. Now with these words I can say, I had been associated with the ASADR from the beginning. Why? How did it happen? ICA is the mother body, created by the Commerce Ministry. They sidetracked more or less the ASSOCHAM. ASSOCHAM then decided to have this body. When it was growing up, the COVID came. Sharmaji took over at that time. So I now leave it to him to take it further up, and all the consumer, how to make it attractive for the consumer. That is most important. We are telling justice, we are singing for ourselves. But who is going to use it? We should penetrate into that. And with these words, Mr. Chairman, thank you very much. Wish you all the good luck.
Thank you. Thank you. Please.
Please.
So my question is, I'm a mediator. My name is Dr. and Captain Mohinder, and from past 10 years, I've been doing mediation in Saket Court, as well as in DDRS. DDRS is before the cases are filed, so I've been doing. The biggest problem which I am facing, I've done arbitration also with Nani Palkewala, and I'm part of you also. Making a mediation forceful is a very difficult task. Now here also, if we are going to address mediation, arbitration, okay, we get a seal of arbitrator, and then which is forced by the law. Whatever the awards are given, they are passed and they are seen that they are honored. But in mediation, when the settlements are done amongst the parties, at times what happens is one of the parties backs out, because they think that while coming into the mediation, it will be a time-consuming process. I mean, they seek time for their litigations. What my suggestion is, if we are going to adopt mediation in arbitration, so why not both the parties will be aligned like a Singapore mediation centers, where after the mediation, arbitration is compulsory to get the seal to honor the awards.
You see, your question is very nice, but it is little premature, because the mediation bill is still pending before the parliament. So your apprehension, many of your apprehension will be answered in that bill. So let the law be passed first, see how much law is being passed. Then we'll look into how much is already covered. Your apprehension, to my mind, would be covered in that mediation bill. But since it is before the select committee, so some changes might be there. But let's wait for the... Yes.
The bill contains a provision that the mediation report or the findings of the mediator, if conclusive, they will be treated as a decree of the court, like the award of an arbitrator. But all of us have to have some patience till the bill becomes an act. Because unless there is a legislation, it cannot be done. But let me tell you, ma'am, you see, once there is a court annexed mediation, in 95% cases, people do not deviate from the report because they themselves have agreed and put the signature. They know that they are before a court.
Thank you.
One last question to gentlemen, please. One last question.
Hello. Good afternoon, respected panelist and Honorable Justice. Sir, I first introduce myself. I am a practicing arbitrator and basically a civil engineer from IIT Kharagpur, having about 10 years experience in arbitration. Sir, one thing I find during the course of arbitration, everything it expedites justice, very good, everything correct. But the, settlement part of it, the finalization part of it takes a very long time, much more than, the arbitration timing. What is the law for that? So where are we really in the ease of justice? Well, arbitration, everything, so the court, it has to be, enforcement is to be done through a court, and that, maybe a district court or on, there are dates after dates, and it years takes maybe years and years, I have found that even an arbitration award is given, the winner of this, award-winning party is far away from getting the settlement dues to him. So is there any remedy, sir? Otherwise, we will never achieve success, sir. I am afraid that I would be soliciting your kind response on this, sir. Thank you, sir.
Sir, just 1 minute, sir. Let me answer his question. Just 1 minute.
Law provides a remedy. So law provides a remedy, and how much period the arbitrator would take, and the part of execution. In fact, after the amendment, the execution part, the objection under section 34 nowadays are very quickly decided by the high courts. That's what I could feel. And you must compare the situation that was prevalent 10 years back and what has happened in last 10 years. How much less time we are consuming. And I am quite hopeful in next 2 to 3 years, the time consumption will be very less because the law is getting settled almost on every corner, almost from every spectrum. Mr. Midha, you can add to this also.
You see, the enforcement of the award again relates to the execution, because award has to be enforced like the decree of a court. So in execution, certainly we have difficulties in our country, and execution, it is not easy to execute. So this law also needs to develop as to how to expeditiously execute, and there are various judgments on this point where the courts have dealt with the execution, but certainly it takes time. Thank you.
Thank you very much. May we request all other questions to please send in the email, and then we will write back.
One more question.
Sir, I am a technology expert. Sir, some of your judgments and handling of the cases was wonderful, and everybody should be informed about it, and you should be writing books. Sir, you should be making crores. Everybody needs to learn from your expertise, sir.
इसका जवाब मैं देना चाहूँगा. Mita Saab was never worried about the money. He is different
No,
kind
sir,
of man.
money
He doesn't
can
want
be donated
crores.
also, sir.
See,
I want crores.
But sir, people should know what you have done.
No, you are. No, I am already
you, sir.
writing books. You see, post retirement, I am now multitasking. 10 days a month, I am teaching law in Galgotia University and also writing books. 10 days, I am doing arbitration and also the practice in Supreme Court and other high courts. And 10 days, the High Court has appointed me administrator of Kalkaji Temple, which is the only Shakti Pit in Delhi. So 10 days, I am serving and at the feet of the goddess. But I am certainly writing books. You will shortly see. But most of the judgments you will find, path-breaking judgments you will find on the website of Galgotia University. They all are there. Anybody who wants to see, they can see. Especially the judgment on
Sir,
what is truth and how to discover truth, that is there in that website.
Sir, I was involved in PRT and fast running of meters. I was campaigning every day, and the court cases were also pending. So the companies were they were, you can say, cheating consumers. So I was helping consumers.
Thank you.
Thank you. Thank you very much, all the guests on the dais, for your kind spending time at making the audience aware, educated enough, and learnings. Thank you so much. Now may I request, moving forward, the panelists of this session, technical session. We have with us Advocate G.P. Madan, Managing Partner, Madan Law Offices. He's the moderator of this session. I may request and invite Mr. Advocate G.P. Madan Sahab to please join us on the dais. We have Mr. Raman Agrawal, Founder and CEO, Jupitize Justice Technologies Private Limited. Please join under that dais. Advocate Venkat Rao, Founder and Managing Partner, Integrate Law Offices. Mr. Gagan Puri, Managing Director, Dispute and Investigation, Alvarez and Marshall, India. Ms. Deepa Agarwal, Associate Partner, SR Batlivo and Associate LLP, and she is the member, ASSOCHAM National Council for Corporate Affairs, Company Law and Corporate Governance. I request and invite all the panelists of the technical session to please take over. This technical session we will have the discussion on and around current status and applicability of ADR in India, recent amendments and changes in the legal frameworks, enforcement related practical challenges, use of technologies, artificial intelligence and increasing efficiency and speed of judiciary, streamlining and strengthening ADR ecosystem in India through use of technology, ADR under Companies Act 2013, ADR in Real Estate Regulation Act, ADR under IBC, labor related matters, and how the stakeholders can be further educated for encouraging towards adoption of the faster and cost effective mechanism under ADR, and how the India can be made a global hub for ADR, and also the panelists would discuss the recent cases and problem solving. So with all this, my opening comments to session to begin, I would request Advocate GP Madan sir to please take over the proceedings of this session.
Thank you, Santosh. Good afternoon, all the participants. And I welcome all my co-panelists, Mr. Gagan, Mr. Raman, Advocate Venkat Rao, Ms. Deepa Agarwal. Friends, the theme of today's session is Ease of Justice in India, Future of Arbitration, Mediation and Conciliation. And after listening to Justice Midha, I'm of the view the theme should be role of mediation under arbitration. But what he has said that during arbitration also he has played the role of a mediator while sitting on the seat of a judge. So that is what I see the future also in India, the role of mediation. And I'm so happy to know that mediation legislation is under approval pending, the bill is pending before the parliament. Because as on date, the mediation has got no legal backing. It's only arbitration for which we have the written legislation. And in arbitration also, sometimes the confusions are there whether a particular dispute can be referred to arbitration or not. Thank you. You must have read in the newspapers a week ago that Bombay High Court has decided in a particular case that if there is an arbitration clause in a tax invoice, that cannot be treated as an arbitration provision or arbitration agreement. What has been decided in that case, that when there was a purchase order and purchase order was exchanged between both the parties, there was no arbitration clause, there was no arbitration provision. However, when the goods were supplied and tax invoice was issued, in the tax invoice, there is a provision that in case of dispute, the matter shall be referred to the arbitration and the arbitration seat shall be so and who has the power or authority to appoint the arbitrator. And when the dispute arose, the person who supplied the goods, who raised the tax invoice, took the matter to the arbitration. Matter went to the High Court for appointment of arbitrator, but the High Court decided this is a unilateral act of appointment of arbitrator. Whenever you are going to appoint an arbitrator, both the parties should be a party to this. At the initial, not at the time of appointment, but at the time of entering into an agreement, both the parties should be of the view that the matter can be sent to arbitration in case of dispute. Here there was no such clause in the purchase order. Unilateral act of mentioning the arbitration provision in the tax invoice does not entitle one party to take the matter to arbitration, and the application was dismissed. But yes, with the liberty to invoke other provisions of other legislations for recovery of the money, that was a separate issue. But in mediation, as we see that there is no role, there is no legal provision as on date. But as Justice Midha also said, that as far as mediation is concerned, that's a in thing, that's the future. I remember around 6 months ago, when IBBI called me to give a presentation on role of mediation under insolvency and bankruptcy code. I also thought, when there is no provision under IBC about the mediation or conciliation, What should I deliver? Then I thought of, because so far I must have handled maybe around 100 plus cases under IBC. Then I reminded to myself that under number of cases, I myself has acted as mediator. And from which stage? First stage, when the application is filed. Rather, first stage, when the demand notice under IBC is issued. The mediation starts then and there. Because the number of cases, the issues are settled on the issue of demand notice. And if they are not settled at that stage, then the next stage is after issue of demand notice, but before filing of the application, or the moment advance copy is served upon. Again, the role of the mediator starts, the number of parties come forward, okay, we are ready to settle. If it is not settled at that stage, once the notice is issued, again the discussion regarding settlement starts. And if nothing succeeds, when the application under section 9, because in section 7 is very difficult to settle. Majority of the cases of settlement are under section 9. And when the admission order is there under section 9, and at that point of time, I tell you, number of settlements are there, and that is the stage for role of the mediator. Recently, only 4 days ago, I got an order from NCLT where a matter has been settled after 2 years of admission of application under section 7. That was under section 7. But now the parties have settled because nobody wants to pursue the case. And at this stage, the matter has been settled. So here comes the role of mediator. The role of mediator is there at each and every stage. And particularly, friends, I tell you, there are great opportunities for the mediators. Even today morning, I was delivering two lectures to Association of Merchant Navy Captains. And when I was discussing with them, they said, nowadays there are a number of issues where the contracts have been entered into between all other parties and the Russian government, or other parties and the Russian parties. Now, number of contracts are being cancelled. Number of shipping lines, they have refused their ships to go to enter Russia. Now, can it be treated now at this stage if the agreement is broken, or if the one party refuses to supply, can it be called force majeure? My answer is no, it cannot be called a force majeure. But if it is not there, then all the agreements are providing for arbitration. And if the arbitration doesn't succeed or arbitrator is not appointed, then I think the role of mediator can also start there. So I was discussing that at that point of time, that role of arbitrator and role of mediators, particularly during this period when there is war and warfare, a number of agreements are being cancelled. Role of professionals is excellent. And I tell you, from the money point of view also, from the international agreements point of view also, I think the sky is the limit for those who are lawyers, the budding lawyers here. This message is for them. Though Justice Midha, somebody said that Justice Midha is not there for money, but budding lawyers, you have to earn money because Justice Midha has already earned money, now it doesn't need money anymore. But a budding lawyer, certainly they need money, they have to have something before you start some other activities or go into some charity and all that. But the opportunities are humongous across the board, across the globe, and you must encash all those opportunities. In one case, I tell you, under IBC, when there was no provision of withdrawal of the application, I remember when we took the matter before Supreme Court under Article 142 of the Constitution of India, and the withdrawal order was passed. In that case, what happened? An application was admitted just for the default of 8 lakhs of rupees. The company's total turnover valuation was 100 plus crores. And for 8 lakhs of default, earlier the limit was 1 lakh of default under IBC, now it has increased to 1 crore. At that point of time, when the limit was just 8 lakhs of rupees, when applications was admitted, promoters didn't bother at that point of time. उन्होंने कहा क्या है, NCLT है ना, क्या है, देखा जाएगा. It's like any other court, कुछ नहीं होगा. But ultimately, when the application was admitted ex parte, and at that point of time, there is no provision of withdrawal of application under IBC. Very next day, when the application was admitted and the IRP reached the office of the promoters, थोड़ा पानी मुझे नहीं चाहिए, मैं वो कर रहा पानी रखवा दो यार, साइड से रख दो प्लीज यार. When IRP reached the office of the company and he met the directors that please hand over everything to me, it was very shocking for the promoters. What has happened? Who are you? We don't recognize you. He said, please, from now onwards, I'll run the affairs of your company and your bank account shall also be operated by me only. He said, what is to be done? Well, nothing can be done. There's no provision of withdrawal. Then what's to be done? You need to go to Supreme Court and file a petition under Article 142 of the Constitution of India. That's the only remedy available to you. And fortunately or unfortunately, that was June vacation time. So we went to the vacation bench, and the very first hearing itself, the application was withdrawn. Not only withdrawn, but the Supreme Court passed an order that all the proceedings pending before NCLT shall stand quashed, because the amount was settled. But this time the cost to the company was not 8 lakhs, but it was approximately 20 lakhs of rupees. Because the other party asked for, give me interest, give me penal interest, give me legal costs, give me the IRP's fees and blah, 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 give me everything. So 8 lakhs of rupees default, ultimately he had to pay 20 lakhs of rupees, but the company could be saved. And the moment the order is passed, I tell you, उसके बाद उनकी आंखों में जो आंसू थे ना, promoters की आंखों में आंसू थे, मैं बता नहीं सकता. But before filing this application, we had to enter into a settlement. And for that settlement, there was no provision. Ultimately, we had to act as mediator between both the parties. और उस समय दूसरी पार्टी क्या कहती, हमने जब दूसरी पार्टी को फ़ोन किया, दिस एप्लीकेशन हैज़ बीन एडमिटेड, तो हमें मिलना है, आपसे बात करनी है. सर, वी आर इन नवी मुंबई, अभी 3 दिन तक तो टाइम नहीं है हमारे पास, आप 3 दिन बाद आ जाइएगा. And this guy was worried that tomorrow if the announcement is there in the newspaper, my whole image will be tarnished. When I went to the entire application, I could find some defects in the application itself, for which action could have been taken on the applicant. I called him again. I said, these are the defects. I'm going to raise this defect before the NCLT tomorrow itself. He said, sir, please wait. We are coming to Delhi tomorrow itself. And very next day they were in Delhi and we could settle it. This is what I'm saying, how the mediator can play a role under various provisions, at the various stages under IBC also. The mediator is playing a role nowadays in COC also, Committee of Creditors. When there are fights among the various stakeholders, among the various creditors, between the promoter director and the creditors, at that time the mediator is also playing a role. So there is a long way, and the role of mediator after the mediation bill is passed is going to increase. I'll give a stop to myself because there are so many other speakers and we have time. I think we have time till 6 o'clock. So each faculty would get not more than 10 minutes. I'm not saying 10 minutes, but not more than 10 minutes. So after this, I'll invite Mr. Raman Agarwal, who is going to speak to us the streamlining and strengthening ADR ecosystem in India through the technology. And this is called ODR in ADR, Online Dispute Resolution in Alternate Dispute Resolution Mechanism. Though there are certain provisions, I'm not saying there are certain provisions under CPC as well Information Technology Act. How far they are effective and how can we take use of those provisions, we would like to hear it from Mr. Raman Agarwal. Thank you very much. Thank you.
Hello. Yeah, this is Raman Agarwal. Good evening to my dignitaries, members of ASSOCHAM, and all the attendees here. So, in all the previous discussions, we were just touching the legal dimension of how to ease the justice or the future of the ADR mechanism. So, I'm taking you to not to the legal dimension side of the ease of justice. I would be basically giving you the another perspective that's called the technology perspective, and how we can ease the justice, from the technology perspective, and how we can streamlining and strengthening the ADR mechanism. As everybody knows, everything is online except justice. And today, because the situation is such that the total population, global population, is almost about 7.5 billion. And 5 billion people have no access to justice. we are only talking about the ADR problems, the legal problems, and we should also consider those people who have no access to justice. When we say access to justice, that doesn't mean it is only his access to filing his disputes. There are the people who have no legal knowledge. They are not legally empowered. You know, what is their legal rights, what is their legal remedies, whether what he is facing is really a legal need or a justiciable needs. So, in my opinion, the ease of justice is not only filing the case to the court. Ease of justice is also how we are legally empowering the people across the globe, you know. And then, so which I say, always say, called the awareness. And second is the availability, whether there are adequate numbers of lawyers, as well as whether their services are available at an affordable price. So altogether, when we say the ease of justice, it has to be considered not only for the purpose of filing their disputes, is also to know your justiciable need and the availability of the resources, you know, which can help you to file the disputes. So now taking back to the legal dimensions, you know, the whole world today, you know, is having two space. One is called the physical space and second is called the cyberspace. In the physical space, we have almost about 7.5 billion people. And in a cyberspace today, now we have 5 billion people. Almost 2/3 of the global population is now living in a cyberspace, you know. And when they are living in a cyberspace, you can see the advent of the internet and especially the information and communication technology. They have changed the way of life, the way of communication, the way of doing business, you know. And this is very, very important in terms of when we are talking of the ease of justice. You know, for an online society, you know, which we are building now, you know, they basically live their life by their own regulations. They are not subject to any jurisdictions, you know. So we should also think for those people how to, you know, make the justice available to these kind of communities, you know. And the online society has no space issues, no time issues, no geographical issues. You know, their communication system has changed from synchronous to asynchronous. You know, there used to be time when we used to call person and you used to pick up the call. Now today, you know, this system is such that you don't even bother to pick up the call and you reply back the call whenever it is convenient to you, you know. So the whole system is changing, you know. And this basically, the internet has changed the whole business dimensions. And now today, the total business transactions, say the global economy is almost about $92 trillion. 3 to 5% of them turns into a disputes, which is almost about $5 to $7 trillion, you know. So disputes is basically a byproduct of every transaction and every relationship. So dispute is growing, but are we able to support this growing, evolving and present needs of the disputes? That of course cannot be sorted out only by the formal judicial system. The Western countries, in fact, has imbued a thinking in everybody's mind. The court is the only solution for your dispute resolution, you know. And that's the reason that there was the ADR system came into pictures 2 decades ago. But there are a lot of challenges in terms of ADR because people are used for a court-like things. They know that if there is a dispute, they can go to the court, there is a room, there is a judge, there is a procedure. But in case of an ADR system, there is no such thing exist. You know, when somebody wanted to make use of ADR, I'm not talking about the large corporate houses where the ADR is their luxury because they know where to go, from where they can hire the ADR advocates and what kind of procedure and what kind of knowledge they required, they know. But what about those MSMEs and individuals? The whole world today, the 97% of the global firms are MSMEs. And think about the individuals who has employer-employee disputes, landlord-tenants disputes. You know, these people have no access to the ADR mechanism. So we should come out with a system where they should also have an access to the ADR mechanism. So what we have done, like say, we are not saying and not trying to make my company hear this. So the same way, like the e-court committee, they came out with the e-court mission. They are creating a foundational digital infrastructure, you know, for bringing the judicial system online. Even by spending 15 years, they also came out with the shift in their approach and saying that just having a virtual hearing or online filing is not the solutions of making the justice system online effective. So they have changed their approach from system to platform approach. Now their foundation vision is the digital court. That is where the Jupiters has done. Now the same way the judiciary came out with switching over their vision from system to the digital code, and they are envisioning a digital infrastructure which is digital native, you know. And same way Jupiters has been working for the last 4 years, spent several millions of dollars and created a foundational digital infrastructure for ADR mechanism. And now on this, we have created various ADR solutions. We have created an ADR platform where the entire process of the ADR can be performed on the platform. You know, as you know, education is not found in the school. Health is not found in the hospital. Same justice is not found in the courtroom. Justice is an outcome of a process. It is a procedure that has to be performed, and only then the justice is delivered. Same way the ADR works. So in short, I can say, when we are talking about justice, there are 4 things. One is there is a judge, there is a courtroom, there is a procedure, and there is a registry or the administrative side of this thing. So that means it's a clear process. And same thing happens in the ADR. There is a judge, there is a courtroom or a venue where all these people sit together and do the mediation, and then there is a procedure, and then there are the case manager or in case of administered arbitration, they are the ADR centers. But the point is, you know, so since this is a process driven, so it is very, very easier to use the digital technology, because digital technology means you can digitize the process. So since it is a process driven, it is very easy to bring ADR system online. So now, like say, for example, we have created the platform where anybody can come and do the arbitration, mediation, and conciliation, right from drafting the case, filing the case, till the end the decision is made there. And secondly, we also started working on the capacity building and created a marketplace. Because the people should know there has to be an address from where they can go to the court, just like going to the court. So we created a marketplace where we have been aggregating arbitrator, mediator, conciliators, lawyers, the ADR centers, and other professionals who are doing the practice in the ADR areas, and having the multilingual capabilities and the diverse expertise. So we are connecting those people to the disputing communities, you know, and we are providing an address where those people can come and access them, and they can hire them online, they can negotiate, they can find their own right match, and they can appoint them online. And if they wanted to do the process performed online, they can also have the arbitration platform, the mediation platform, and the conciliation platform. and where they can do the process online. So the point is not that we do not have the clear procedure, but the point is that there is an imperfect execution of the procedure. If we have the right tools or the services available to perform that procedure, believe me, the outcome would be quite correct. Just like he was saying that there was an error in the date, in the order, and he has to spend long time to get it corrected. But believe me, in case of digital platform, such kind of mistakes will never happen, because most of the information would automatically get filled up. There would not be a repetition of the information every time, and the quality of the information would also increase. So we should basically more focus on the technology as well to bring the ease in the justice and to strengthen the area. So I will not take more of the time. I have a lot of things I can discuss on this side, but my another colleagues, they would also give you valuable information. Thank you very much.
Thank you. Thank you, Mr. Raman. I think we need to invite you for a demonstration also, practical demonstration, how that will be, actually through that only we'll be able to understand it more. But I have a very small question, how effective it is from cost point of view?
Yeah. See, the number one, because there are three cost elements. One is called the advocate fees. Second is basically your logistics cost, because you have, say, for example, if it is an international arbitration, you guys have to go to the venue. Say, for example, if the arbitrator is in Singapore, is inviting in Singapore, or so these are called the logistics cost. So since this is a technology platform where you can find all type of lawyers, there's a healthy competition even among the lawyers in terms of offering their fees. So you can get the lawyers as per the affordability. So this is one angle which reduces the cost. And second, all of your travel cost, all of your conferencing costs, you're hiring the conference room, and you are also hiring a lot of case manager or administered ADR centers, but in case of technology, because the use of artificial intelligence and other technology make the process so easy that for a smaller claim amount, even one can represent oneself, So there are huge savings as per my estimate, which we can discuss later on. It will save cost by over 70 to 80% as compared to if you are holding arbitration through the conventional means.
Another small question on a lighter side. Is there any plan that you can overtake the court work also?
No, we are saying that we are becoming the extension to the court. We are strengthening the court.
Extended arm.
Yeah.
Extended arm of the court. Extended arm. Okay, thank you. But as you said very rightly, it's really going to help the MSME in a bigger way.
Yes. My focus is to help out the MSMEs, because in India we are 6.5 crore MSMEs, and 97% of them do not go to the court because they have very limited capital, to get their dispute resolved.
And that's the agenda of the government also, to help the MSME sector. And I tell you from IBC point of view, because IBC is close to my heart, from IBC point of view, recently the government has come out with a pre-package insolvency resolution process, particularly for MSME sector only. And I give you one more figure, that people accuse and abuse IBC and nothing has come out of IBC. There are more haircuts and liquidations are more, resolution plans are very less. Out of total 7.5 lakh crores of the claims filed, only 2.5 lakh crores has been recovered by the creditors. But one figure people are missing, because that's not there in the public domain, that around 6 lakh crores of rupees has been recovered by the creditors, the applicants, before admission of the application. 6 lakh crores. And that's not a small figure. And majority of these creditors, the applicants, are from MSME sector only.
Wow, that's great. That's great.
Thank you. Thank you so much, Mr. Raman.
Yeah, thank you very much.
Now to our expert, the only one. Whenever we come to talk about the real estate sector or the RERA, I think the only name comes to everybody's mind is Mr. Venkat. And Santosh also referred to that in one of his cases, Mr. Venkatraw plays the role of a mediator. And you know that whenever any dispute is there, particularly between the builder and the buyer, various remedies come to our mind. Should we go to civil court? Should we go to RERA? Should we file an application complaint under Consumer Protection Act? Or should we go to NCLT under IBC? Or practically, मैंने देखा है that investors, they go everywhere. At least 2 or 3 of the forums. They run pillar to post, but hardly they get any justice. Because under IBC also, hundreds of companies have gone into, real estate companies have gone into IBC. But very few instances are there where the settlements have happened. And God forbid if the company goes into liquidation, all these home buyers or the allottees are unsecured creditors. They are not going to get a single penny out of these cases. So Mr. Venkat, being a mediator, what do you suggest to us whenever there are disputes, whether it's between the builder and the landowner or the builder or the allottee, how to sort out these issues?
I see that this forum has been very kind, and especially the panelists and even the organizers have been very kind to me. While Santosh mentioned about me on mediating something for him, and Madan Sahab has been very kind in bestowing all that about real estate, and RERA being, something that I come up as a name. But it's a, real estate industry, I would say, is something which is very close to my heart, like IBC is to Mr. Madan. So Mr. Madan and co-panelists, Mr. Puri, Mr. Agarwal, and Ms. Deepa, thank you for, probably bearing with me for a particular industry that I'm going to speak of. Now, this industry per se affects every individual probably sitting here or otherwise in this country, or even for that matter across the globe. So this industry, especially if we talk of real estate, I should mention that due to its sheer magnitude, if you see, the housing is one of the industry's main stay, where we talk of Pradhan Mantri Awas Yojana, which is the largest affordable housing program that is going to come up. This market size of the real estate industry, especially housing, is going to be over maybe 1 trillion by 2030. 2030. So naturally, this industry is a very important industry. Almost 50 odd industries actually correlate and do exist along with this industry. So naturally, economy this is the third largest contributor to the employment. Definitely is a most happening industry which affects everyone's life. Now, therefore, what happens is, unfortunately, over past maybe 5, 7, 8 years, the industry has been going through a lot of, turmoil, and thereby now if anything we talk of a real estate industry or a builder or a promoter, the first thing that comes up to anybody's mind is a dispute. And the first thing that anybody, most of the people ask me, मैं यहाँ invest करूँ, वहाँ invest करूँ, तो सबसे पहले ये पूछते हैं कि साहब वो दे देगा फ्लैट, या साहब वो उससे अंडरस्टैंडिंग या एग्रीमेंट ठीक हो जाएगा, या मैं कोर्टों में धक्के खाता रहूँगा. This is generally the question that comes to me if anybody asks me about any kind of an investment, or even to buy a house, or even a small understanding or an agreement that comes through. Now, that has been because it's just that these 7, 8 years or 10 years have shown to be more affecting, or it's more awareness that has come through. But actually, traditionally also, अभी मिधा साहब ने 3 judgments अपने बता रहे थे, उसमें अगर आप observe करेंगे 2 real estate related थे. So it is that kind of, so it is traditionally we have litigation. It's said that maybe plus more than 25% plus of the litigations in the courts pertain to real estate, meaning thereby कोई tenant litigation होगा या landowner litigation होगा, so on and so forth. Therefore, I would believe that alternative dispute resolution is going to be the in thing. Yes, it has been so. Traditionally भी अगर देखेंगे real estate में काफ़ी, even at पंचायत level ही, अगर आप even historically भी देखेंगे, आप ये महसूस करेंगे कि कोई झगड़ा हो रहा है तो पंचायत में सेटल करा दिया, इसका ये ज़मीन होगा, इसका ये टुकड़ा ज़मीन का होगा. ये हम एजेस से सुनते रहे हैं, and this is how the law has also evolved. while law has evolved, what one sees even today also, I am just not going to mention about law, what is the trend that is happening is what I same train saying before moving further. Even today, even in structured transactions or even in disputes resolution, as an advocate, I would tell you more than the court settlements or the settlements that have happened through the orders of the courts, most of them been through either arbitration or through probably settlements. Even after court decrees, what we have realized or seen over the period is, it is the subsequent settlement that is happening, as Mr. Midha, and there was a question on execution, so on and so forth. Eventually it is an agreement that has been entered into by the process of a mediator, or probably maybe to a certain extent few people getting together, acting together as mediators and settling the ultimate issues between parties. Now, why we have these issues? Mostly what I see is this industry, because it is a high value, high stake industry and then a high risk. So therefore, because of this kind of a high risk and high value, there is a mistrust also. Whether be it between landowners, whether be it between developers, whether it is a simple transaction of two developers entering into and getting into a project, or whether even to the extent of getting the approval, so on and so forth. Now, I was reading somewhere, we have 37 approvals in a construction industry, leaving alone the critical industry approvals itself. So if it is land to launch, as I call, land to launch, if a project has to come to its shape, the minimum approvals that are required are about 23. That's what, if I remember correctly. Now, the time that it takes puts strain on most of the agreements, whether be it a developer and a landowner. Mostly you see that landowner has contributed the land and he expects a certain timeline within which the project is delivered, and they have these revenue sharing models or they have these area sharing models where they expect that in a certain period of time they would get it. Ab hota kya hai ki there is a governmental intervention, you have to get approvals, they get delayed despite even explaining the situation and knowing and understanding the situation. The stakes are such that things go wrong. Now, if you look at it from the developer perspective, and if you look at it from the landowner's perspective, you do believe that developers also play smart, or even at times, crooked. I'm sorry to use the word, but yes, it is that way this industry is. So that transpires eventually to the common man who actually eventually buys a property into it, finds himself in a chaotic situation where two, either landowner builder is fighting out or there are JV partners fighting out, and who's losing out? It is this particular home buyer who is invested, and thereby the larger economy gets impacted. Now, apart from these, what we also see is disputes like between contractors, those who have, the idea of shifting over, frequently the contractors is also a problem in this industry. That also most of the times delays the projects. So these issues, mostly what I have realized is, while a lot of agreements are entered into, and over the last at least 7-10 years, what we are finding is there are clauses. There is an agreement clause which actually mentions about arbitration, and that arbitration process is generally invoked, usually at a drop of the hat, I should say. And they go through this process mostly as a mechanism to sort of a negotiating, rather than actually finding a solution in an arbitration court also. Because eventually it ends up with a settlement and a mediation. So what I believe is, now that mediation bill is coming through and pre-litigation mediation is also proposed in it, and then Honorable Justice Mishra and Justice Midha are actually mentioning that it could be enforced as a decree, probably we will find more mediations happening on a proper, in a legally binding fashion, which is a good thing to happen. Now, reason for it, I would say, is that the amount of opportunity loss, amount of business losses, and the amount of I would say the manpower, I would say the lack of time, the cost overruns to the projects usually would be taken care if a process of mediation is preferred at first end, then a litigation could be initiated. Yes, arbitration is now a world act, as Justice Mehta and earlier panelist and even Justice Mishra was mentioning, it's now almost over 10 years, it is over a decade, it is now a well-developed law. We have a lot of clarity in it. Mediation is coming forth, and I would say it would be a big plus thing. Only problem that what we see is, as Madansa was just mentioning about consumer disputes being in the ambit of arbitration. Now, Honorable Supreme Court had taken a view, and yes, it is a correct view, that because builder-buyer agreements are one-sided, dominant, and therefore, even if there is an arbitration clause, it cannot be enforced, and therefore, the forum as a arbitration was put out of those builder-buyer agreements. But what we see with even RERA, good or bad experience of Santoshji, is trying to bring in a conciliatory forum. And even in this mediation bill, I was fortunate enough to be part with Senior Advocate Mr. Sharma on a certain presentation to the Parliamentary Committee. And what we propose there also is that the consumer forum is already captured in for the mediation to be referred to. We have referred that even RERA, same kind of a provision should be put in, so that even disputes between builders and home buyers could also be reasonably settled in a mediation process. The law has to come through, hopefully it will come through, but even consumer disputes, I find today, because despite having courts, despite having RERAs, despite having consumer forums, the kind of litigation that piles up and the time taken piles up. So it is better to have a proper mediation process, and I hope we would have a much stronger mediation. And I would like to thank once again ASSOCHAM, Madan Saab, and everybody else. I'm going to hit to the timelines, I hope, Mr. Madan.
Thank you. Thank you so much for sharing your practical experience. Now I come to Mr. Gagan Puri, Managing Director, Dispute and Investigation, Alvarez and Marshall, India, to share his thoughts on commercial determination in ADR.
Well, thank you, sir, and good evening, everyone. Not being a lawyer, and so I can afford to not ask for adjournments and try and stick to my allotted time. I'm really, when one thinks of commercial determinations, I remember a story from long back. A person goes to Amsterdam and sees a very shady character lurking in the street, and he asks him, "Will you sell me a gram of cocaine for $100,000? The guy says, "Sure." And then he turns and says, "Will you sell it to me for $5? He says, "What do you think? I'm a drug peddler." He says, "We already established that by the first question. Now we're just negotiating." So whenever I think of a dispute, and especially being a forensic accountant, expert witness in arbitrations and litigations and mediations, at the end of the day, it all comes down in certain ways. A litigant's or an arbitrator or any party in disputes propensity to either settle through a negotiation or go for litigation comes back to what value they expect to get out of the matter. So, whenever we looked at it, my initial appointments were all litigations. Always parties in dispute, we put out papers and papers for court. But more and more as we see the evolution of ADR happening, I'm pleased to say that today, we are increasingly called into negotiation stages. We are increasingly called into mediations and conciliations and try to get it resolved before, an arbitration or a litigation commences, which I think are extremely, extremely favorable sort of things to do. A negotiation is straightforward at times, at most times, if you have a nice mechanism in either your clause or a nice understanding between parties on how to financially settle the matter. Then legal interpretations don't apply, everything, it's easier. If there's a mechanism, a formula, saying that, okay, this is how we're going to arrive at what we need to arrive at. But more often than not, in our experience, it's been that clauses don't provide for it. The big difference I've seen over the last 10 years, a lot of the contracts, especially, written over the past 5 or 7 years, where we've got good arbitration clauses built in. You provide for seats of arbitration, modalities. People have also started putting in requirements on how an expert determination would be made, and I think that's a really welcome sign. If the future of negotiation has to go through, I think this is something which should be promoted a lot more. The second is talk elements. The first is paperwork. Most cases I see lack the appropriate paperwork to make commercial determinations. So, we write clauses, we write good contracts, but the follow-through, even I'm telling you with some of the biggest companies in India, the follow-through is extremely poor. And that's where, an expert's hands start getting tied, because if you don't really have a paperwork to go back and make a convincing argument, you end up, probably losing credibility over it. The second is the evidence presentation. I can write a nice voluminous valuation report that I can guarantee you no one in this room will understand. But that's not what the purpose of an expert report is. I have found it so easy to demolish opposing experts on the other side because of the complexity of the case they have presented, or because of the convoluted terms and jargons and everything thrown in, which a lot of times is in the experts area of expertise, but it's not in the tribunal area of actually getting to a judgment. So as experts, we often forget our overriding duty is actually to the tribunal. It is to help the tribunal come to a determination. And I think when we talk about ADR, we talk about negotiation, or we talk about conciliation or mediation, the same principle has to apply. So any commercial decision that comes back, the presentation has to be articulate enough for the parties to understand, for any person who's sitting as a mediator or a conciliator, if there's no, if the parties agree to one, for them to do that. The third is the basis for expert determination. Again, I've seen that as a major pitfall. Most expert reports tend to get challenged because you're unable to provide a strong basis or a logical argument. You tend to swing towards one party, which again brings me to the fourth point I want to make, is objectivity. If an expert is not objective in terms of putting his work through, the credibility is gone, and there is no way either the parties will agree to it, or in future any arbitrator or any court is likely to give credence to that report. I think I want to touch a very tricky part quickly, and that is damages. To me, when there's a negotiation or a conciliation, it is better to keep damages out, because if you start putting damages in, you will rarely get a party to agree on a methodology to settle the claim financially. So damages come in more when there's an arbitration or a litigation, and I think that's really the step process. If you're really trying a negotiation or a conciliation, it's sometimes good to eat the humble pie, but in the interest of actually reaching a quick negotiated settlement, you may want to keep damages out, because damages computation, especially as an expert, tends to get very tricky, and the acceptability under law also, you'll have to really go back and do work around it. The second last is actually the remedies. And I think, whether it is specific performance, whether today we actually, are being asked to give expert reports, let's say asset tracing reports, to actually support specific performance. I think it's again a very important factor, because a settlement or a conciliation is not going to be effective if you are actually able to consummate what has been agreed. I was in a matter recently where the order was read out by the mediator saying this is what needs to do. Both parties started congratulating, and I was like, you guys have no clue what you agreed to, because whatever the mediator has said, there is no way you're really going to be able to carry it through in terms of splitting your business. It is just not going to be technically, financially, or operationally possible to do that. So really, the remedy of what's being asked for is an extremely important part. And I think lastly is cost. A lot of time people say involving an expert is adding more cost. But look at it this way, if you don't involve an expert, the cost of continuing or a prolonged dispute is going to be way more than getting professional help to actually sort. Again, I'm not here to make a sales pitch saying that experts should be appointed, but I'm just saying that at least in some of, for a speedier, for the ease of arbitration or for the ease of ADR, it is extremely important cog in the wheel to get that done. So I think a lot of good trends have happened. If you look at the case work coming up, in mediations or conciliations where experts are involved. I've been doing this over 2 decades, as I said. From a few cases every year to constantly being in front of tribunals or in front of ADR panels. I think, to me, that's really where a lot of difference has come. I am personally really bullish about the value the process adds. I have seen clients of mine who've been extremely satisfied and who've got results today, instead of prolonged sort of litigation costs and prolonged if for lack of word in their eyes delayed justice. So I think if you can give up something today to actually move your business and your operations forward, it is far more valuable. And money in your pocket today is far valuable probably than money coming to you down the line. So with that, thank you very much. Would love to take any questions if you have any.
Thank you very much, Mr. Gagan. Excellent. Now, I think labor law we have to have at the end. At the end. Now we come to the role of mediation under Companies Act 2013. Friends, as all of you know, those who are practicing or studying the Companies Act, they know there is a particular provision under Companies Act where we talk about the panel of mediators and conciliators where, where any party to a dispute may apply to NCLT or NCLT or to the central government for referring the matter to mediator or conciliator as the case may be, or NCLT of its own may also refer the matter for mediation or conciliation. There are a number of situations where the mediators have to play the role. It's not necessary that only the mediator or conciliator as empaneled with the government, with the regional director are playing that role. Even in many cases I've seen we the lawyers practicing in company law are playing that role. The disputes may be with respect to the allotment of shares, maybe with respect to fixed deposits, maybe with respect to transfer or transmission of shares. Sometimes the disputes are there in case of a proposed scheme of merger or amalgamation, where some of the parties are filing objections and they are not giving their consent. Though requisite voting is there, but still the courts are entertaining even a small objector also. So at that time you have to play the role of a mediator. And the painful area of mediation under Companies Act 2013 is section 241, 242 of the Companies Act, Operation and Mismanagement, where majority of the petitions are being filed by the one partner against the other partner, one friend against the other friend, father against the son or son against the father. Recently, a case has come to me where wife has filed a petition against the husband. Now both the petitions are going simultaneously. One divorce petition, another is this operation mismanagement petition. Wife wants to take control of the assets of the company. Now husband is coming to ask me what is to be done. Now you see this petition, how many allegations are there? See the divorce petition, how many allegations are there? Do you want to levy counter allegations or you want to find some route of mediation? Please decide it. Because I am always in favor, I am against my profession to be very frank, I am always in favor of mediation. मेरे ऑफिस में ना क्वार्टर में एक मीडिएशन तो हो जाती है ऑपरेशन मिसमैनेजमेंट की. मैं कहता कोई बात नहीं, फीस नहीं मिलेगा ना, कोई बात नहीं, बस प्लीज सेटल इट डाउन. क्योंकि कोर्ट में जाके जो खड़े हो गए ना एक दूसरे के सामने, जो एलिगेशंस आपने लगाए और वहाँ जो सबके सामने बोलोगे, आप नहीं, अभी तो लिख रहे हो आप, जब सामने बातें होंगी ना बर्दाश्त नहीं कर पाओगे उस समय. I remember couple of years ago, just before the COVID, a case came to me where old father and mother, they have filed a petition against their own son, daughter-in-law and grandchildren under 241, 242. Now the son and daughter-in-law come to me. Okay, now do you want to level counter allegation against your mother and father? Do you want to do that? Or please try to find out some mediation process. उन्हें लगा ये लॉयर हमारे काम का नहीं है. 4-5 महीने लगे, हमने रिप्लाई फाइल नहीं किया, मेरे अंदर से आवाज़ नहीं आ रही थी हम रिप्लाई फाइल करें. They changed the lawyer. No issues. But recently मुझे पता लगा है जो दूसरा लॉयर भी उन्होंने पकड़ लिया है ना, उसके थ्रू भी अब मीडिएशन हो रही है. एटलीस्ट फाउंडेशन मैंने बना दी थी, अल्टीमेटली वो मीडिएशन ही हो रही है. तो दैट्स द रोल ऑफ मीडिएटर अंडर कंपनीज एक्ट. Now over to Ms. Deepa Agarwal, Chartered Accountant, Associate Partner with SR Botley Boy and Associates, to enlighten us on this role of mediator and provisions related to mediation under Companies Act.
Thank you so much, sir, and good evening to everyone. So I think Mr. G.P. Madan has already set the context and made my work simpler. So he has given a very good example of how he helped actually in real life, how mediation really helped. So my co-panelist and everyone mentioned about the disputes and, specifically in the real estate sector. So being a chartered accountant, obviously my mind was working, very much on the accounting, auditing, and the legal issues as well. What I just want to say here that, in the mediation and conciliation, which is there in Section 442 of the Companies Act, and as Mr. G.P. Madan rightly mentioned, that Section 241 and 242 of the Companies Act, which is on the prevention of operation and mismanagement, is the most painful section. Even when you talk about the companies and you listen to the, read about the shareholders' dispute, many times the shareholder disputes are pending, and which makes the, it becomes really challenging for the companies to get even the financial statements closed. Therefore, the mediation, the role of a mediator as well as a conciliator becomes very important. And even in Companies Act 2013, when it was amended in 2013, Section 245 was introduced, which talks about class action suits wherein the shareholders can file, a percentage, 10% of the shareholders can file that class action suit against the companies. So why the provisions? So if you talk about that, we mentioned about the mediation bill, and we heard so much about with the, the knowledgeable experiences shared by, the other panelists. But if we talk about why there was a need for this provision in the Companies Act, so as per the Standing Committee report, the very purpose to create such panel was to enable voluntary arbitration. So again, there is nothing imposed. So the way it works here also in the Companies Act, it's not imposed. The two parties have to agree and understand that, instead of just going into the court of law, and as Mr. Madan was explaining, that putting those arguments and talking, it's better to reach an amicable solution through a mutual discussion and take it, which is in the best interest, and to save time as well as cost. So I think, there's a process by which parties will, wherever there's a dispute, as, it could be relating to your merger, it could be relating to some disconnect with the creditors. So any proceeding which is pending before the central government, NCLT, or National Company Law Appellate Tribunal can be actually given to the panel of the mediators or conciliators. Also, I would like to mention that, it's not just they have the section prescribes the criteria, which includes even the professionals. So besides lawyers, judge, even a chartered accountant, cost accountant with a continuous practice of 15 years can be appointed in the panel. So the rules also provides the, the practical implementation side, that how it works. Also, I would like to mention at least minimum, 3-4 differences which one should understand. What is the difference in the company's law rules when we talk about and the Arbitration and Conciliation Act? So Rule 6 provide for application for appointment of mediator or conciliator and makes it mandatory. So which means it is very much mandatory that the central government or the NCLT or the NCLAT should refer the matter to the mediator pending before it for mediation and conciliation. And such application has to be made in Form MDC2. Whereas if we talk about the Arbitration and Conciliation Act, then that can be even with the consent of the parties, or where the court feels that there's a scope for settlement under ADR mechanism. So there's a big difference between the two. So NCLT or the central government will have to, first of all, refer the proceeding to the mediator. The second difference is that Rule 11 regarding the procedure for disposal of matters mandates each party to provide the mediator or conciliator, as well as exchange amongst them a brief memorandum setting forth the issues which needs to be resolved at least 10 days before the session, which means they will have to, as Mr. Madan was explaining, they will have to write and explain what are the issues, on what grounds the dispute is being filed, what is the issue on which the mediation is required. Whereas if we talk about Section 65 of the Conciliation Act, so under Section 65, conciliator has to ask for the information from both the parties. Other differences, Rule 14 provides that if a party fails to attend a session or a meeting fixed by the mediator or conciliator deliberately, so let's say if it happens twice and the party fails to attend the meeting twice, then the mediation or conciliation shall be deemed to have failed. There is no such automatic failure of mediation and conciliation under the Conciliation Act. So while there are enabling provision under the Companies Act, but yeah, I think probably some sort of pre-mediation or the is very much required to make it faster, to ease the burden of these quasi-judicial authorities. Mediation bill is there very much, so I'm sure while it takes care of the, when we are talking about the other practices, but in the Companies Act also, it's very much in the best interest of the stakeholders if the government also looks into the amendments in this act. So I think many of you would have even read the recent report of the Company Law Committee, which talks about ease of doing business in India. And we are here talking about ease of justice in India. But somewhere there is a correlation. So therefore, it is very important that while these rules under the Companies Act have great potential for effective resolution of disputes arising under the Companies Act, but yes, it has to be given, in practical implementation, that how far it is used, instead of just waiting and for the NCLT to, kind of resolve the dispute, which takes longer and longer period of time. So yes, another point which I want to mention, while there is a specific requirement for the training for the mediators when we come to the professionals, at least. I think that is something a very important aspect which probably the institute should think of. And there is a need for building capacity to make it, faster in this thing. So probably, this is something which I just want to mention from the Companies Act perspective. And with this, I will just like to thank Santosh Ji for inviting me, and thanks to all of you. Thank you.
Thank you, Deepa. Thank you so much for giving us an overview of the provisions with respect to mediation and conciliation under Companies Act. And I'm thankful to you that you refer to this CLC report. Friends, this CLC report, the Company Law Committee report, has been released by Ministry of Corporate Affairs on 14th of this month. And if you go through this around 95 pages report, if you go through the report, you will see that majority of the recommendations of this report are actually towards ease of doing business. And majority of the recommendations are nothing but giving clarifications on the interpretations of various provisions. I don't think there are going to be many amendments, but more than the amendment, there are going to be clarifications. And in my view, now the government is, as far as Companies Act is concerned, the government is adamant to move towards ease of doing business. It's a fantastic report. All those who have not read it, please go through this. And if some suggestions or feedback is to be given to the Ministry of Corporate Affairs, please do that. Thank you so much, Deepa. Thank you. Now, as far as the last session, last faculty is concerned, Mr. Michael Dias, who has to speak on the role of mediation in labor laws. I think he has not come, he has conveyed his inability. But to interact with us, he has sent us a 7 to 8 minutes of video. And I'll request Mr. Santosh to please play that video.
India's traditional judicial system is heavily loaded with number of cases and a delay in the delivery of justice. It has adversely impacted the economy of business and the country as a whole. Since the morning, we have been in discussion with regards to arbitration in the context of commercial disputes. However, I wish to discuss the importance of the ADR mechanisms, that is the alternative disputes redressal mechanisms, in the context of an industrial dispute. We are all familiar that an industrial dispute, either for wages or better conditions of service, if not effectively addressed at its initial stages, may escalate, leading not only to man-days loss of production, but may even take an ugly shape in the form of violence at the workplace. The Industrial Disputes Act 1947 effectively addresses this issue. So does the Industrial Relations Code 2020. But regrettably, it is our observation that the government, and more particularly the Ministry of Labour and Employment, has not emphasized the great potential available for dispute redressal through the ADR mechanisms. Let me illustrate. Section 9 capital C of the Industrial Disputes Act 1947 provides for the establishment of a grievance redressal committee in every industrial establishment employing 20 or more employees. These committees, if constituted and function as are envisaged in the letter and spirit of the law, it could work wonders for the Indian economy, but the regret is that the Ministry of Labour and Employment has not accorded the support and synergies for the various ADR mechanisms available under the statute. In this regard, on a perusal of the Industrial Disputes Act, it is observed that there are statutory provisions that provide for conciliation. But the regret is that these same conciliation officers in the forenoon are LEOs, means Labour Enforcement Officers, who are required to prosecute the employer for non-compliance of various statutory provisions under the various labour laws, including the Factories Act, the Shop Act, the Wages Act, including the Industrial Disputes Act. But in the afternoon, the role assigned to them is that of a conciliation officer, when he is required to plead before both employers, workers and their trade union representatives to arrive at an amicable settlement. This change in role does not facilitate effective ADR activities. In fact, to my mind, the conciliation officer is more a Dr. Jekyll and Mr. Hyde. This same officer is required to play two entirely different and distinct roles. While we all understand that a conciliator, a mediator, is one who reaches out to both parties as friend, philosopher and guide. Unfortunately, the Ministry of Labour and Employment does not recognize and they do not reward the conciliation officers for having settled an industrial dispute. Thus, there is no incentive available whatsoever to a conciliation officer for having made strenuous efforts and in some cases even to stake their personal reputation in bringing about a settlement. I have had personal experience and exposure to such situations at the beginning of my career about 40 years ago, when I recall conciliation officers would go out of their way to study, prepare, discuss and to convince the parties to bring about an amicable settlement, so that the ultimate goal being that there is no production loss and also simultaneously that the workers' interests are fully protected. That becomes a very important aspect. In such an environment, there is absolutely no institutional support available to the conciliation officer to broker a settlement in the case of an industrial dispute. This aspect, to my mind, needs special attention from government to reduce disputes as also to encourage the ADR mechanism. The problem does not lie on the doorstep of the bureaucracy, but also with the courts and the judiciary. Let me explain how it actually works at ground level. An industrial dispute raised by a worker or a trade union is initially instituted before the Labour Office. The parties to the dispute are called to appear before the conciliation officer, who is required to mediate and to find common ground to arrive at a settlement. However, what happens in reality at ground level is that based on several judicial precedents, the conciliation officer is not encouraged to resolve the disputes through the ADR mechanisms, but to refer the dispute under Section 10, read with Section 12 of the Industrial Disputes Act for adjudication to a labour court or an industrial tribunal. Here, let me illustrate what I'm trying to share with you. The most common dispute between worker and employer would be something relating to wages, overtime payments, wages for leaves and holidays and such other things. These issues, to my mind, are purely based on empirical evidence. The employer is required to produce his attendance record, his wages record, and on the basis of that, a determination can be made as to what is payable to the worker. In case the conciliation officer is adequately supported to bring about a settlement in these issues, automatically a large number of these disputes would stand resolved at the level of the conciliation officer, thereby strengthening the ADR system.
Now, coming to end of this session also.
Let me communicate my thanks to Mr. Vaikandas also virtually, And he has taken pain at least to be with us virtually through this video. He has made a number of requests to the government. I think there was a golden opportunity with the government through these 4 labor codes to take care of all these issues and the proper mediation and conciliation provision could have been provided. Because we see the number of disputes are there as far as the labor is concerned, and number of industrial disputes are there. This is a golden opportunity, and I'm sure the government has missed the bus. Maybe while implementing all the 4 codes, something can be done so that these issues which hamper actually the production and the supply chain in the corporate sector can be easily taken care of. Thank you. With this, my thanks to all my co-panelists sitting here for having a wonderful session. Thank you very much.
Thank you all for this wonderful session as well, and it's a great honor for ASSOCHAM to have you at this first program of this particular Department of Corporate Affairs that we have initiated physically after the pandemic lockdown. So thank you very much. I am sure that the participants, audience, though they would have taken this session very much useful and worth spending time over here, and we will definitely keep on continuing with similar kind of the physical activities going forward, subject to the coming time, which the news is also again spreading about number of cases rising. Hopefully that we are again coming out with safe health, and we will continue with this. Thank you very much, and I would like to invite.
I have a question with Mr. Puri.
Yes,
regarding that technical evaluation, when you say that there is a technical evaluation of any of the claims, and when it is referred before a mediator, how means there could be reports from both the sides of the parties, and which report should be catered? That is mainly.
Yeah, so that's really the choice of the mediator and what parts of the report he would choose to do. So it's really up to the arbitrator or the mediator to select on those. How these parties would put those?
It is upon the mediator, means how mediator should analyze that report should be based on which aspects.
So I think it's very clear framework on this now. So the first thing is hot tubbing of experts. The second is having a joint expert report and then looking at the areas of differences. And that's where the mediator's input should also come. I think in the interest of time, maybe we can take it offline. I'll be happy to share my
thank you.
Thank you.
So there is one announcement over here that the AICADR, that's the ASSOCHAM's International Council for Alternate Dispute Resolution, that honorable senior most person sitting out here, Captain J.S. Gill sir. We welcome and honor your presence, sir, and who has initiated this AICDR at ASSOCHAM and now taking shape. We welcome and invite the membership that we have reinitiated this year. So those who are professional lawyer or carrying along the expertise in ADR mechanism, they can contribute and participate. We welcome you as to join as member, and would like to finally invite you for the snacks and tea that we call high tea, and we will come to an end after that particular. So please welcome to all of you. Thank you so much. Here only or